Okay, good morning, everyone. We have 6 cases on today's argument calendar, and we'll begin in appeal number 24-2573, Arriaga versus Thomas Dart, Sheriff of Cook County.
Good
Mr.
morning,
Cooper,
Judge
nice
Pryor.
to see you.
Yes, sir. Good morning, Judge Scudder. Good morning, Judge Kolar. I've reserved about 3 minutes. I want to make some points that I think would enhance the briefing already done by my client. My client ad nauseum, played hostile work environment. She did it under federal law, and she did it under ICRA. ICRA is, in fact, more expansive, as the Sagamon decision shows us. Second, my client lives in stealth. We know from the scientific literature and the expert retained by the plaintiff that living in stealth is a real phenomenon. And it is concerning that the district court found, not precisely as to living in stealth, but as to things tethered to living in stealth, that she was lying. And I can tell you that Officer Arriaga was not lying. She was living in stealth. She made clear that she interacted with other transgender people. In the brief, in the opening brief, I talk about Coptic Christians and how they would talk and interact with other Christians. In the slave era, we have slaves talking with one another in the evening, talking, that is practicing Christianity, teaching one another how to read and to write. That should not constitute perjury. That should not constitute a fraud upon the court, because people maintain relationships with people who are like them. That's essentially what I have to say. Unless any of you have questions, I'm ready to answer.
Are we able to get to the merits of this case, particularly the first substantive due process?
Okay.
Are we able to get to the merits?
Yes, Your Honor, but I need more of a sense of what Your Honor is thinking, and then I can certainly answer the question.
Why is this not time barred?
Okay. In October of 2018, this is months after the police academy, she experiences yet another disclosure. And it's still a hostile work environment, but it's 2 different cohorts of people.
So if we want to restart the clock at October of 2020, tell me what happened.
I'm sorry, I said 2018, I apologize.
I know what you
Yeah,
meant.
okay. So I'm sorry, say it again, please?
Why is that a disclosure? Why are you characterizing that as a disclosure?
Because the plaintiff testified, it's a disclosure. We have Sergeant Keyes' email, although the defendants, both defendants, interpret, when I say both defendants, Metra defendants, Cook County defendants, interpret the email in a way that I don't think is accurate. We have a new environment. Again, she's in the Metra station house. Prior to that, she's in the Cook County Police Academy.
We don't want to get away from the legal analysis of why this was a disclosure. So let's talk me through why we're characterizing that as a disclosure.
Okay, so she's in the police academy, and then she goes to Sergeant Keyes and she says, people are talking about me, people are saying that I am trans, and on top of that, they're asking questions amongst themselves. You know, does she have testicles, male testicles? She describes crying. She describes being very upset when she goes to Sergeant Keyes. At that point, we hear that Mr. Perez tells Deputy Chief Riggio, you know, take care of it. But even Perez admits he never follows up, and Riggio never gets back to him. But, I mean, that's another point.
But the October 2018 disclosure was from
You said
Sergeant
2019. You mean
Keyes
2020.
to Commander Mack.
Right, it's Keyes. It started with Keyes.
And he discloses that your client has come to him with a concern.
I think you're referring to Sergeant Kamek. So that's over here. That's Police Academy. A separate.
No, I'm talking over here with,
Okay.
with Metro
Mr. Cooper, stay
Sergeant.
at the podium, please.
I'm sorry.
We've had
Yeah.
this happen. I know you don't have to apologize, but it's being audio recorded.
Yeah, I
Okay,
apologize.
so it gets all messed up.
I
yeah.
feel better apologizing.
You don't have to apologize. Go ahead.
Okay.
So the October 25th, 2018 email, is that the one you're talking about?
Correct, Sergeant Keys.
Okay, he's writing to Commander Ryan Mack.
I agree.
Okay, so what is the disclosure that restarts the clock?
Arriaga goes to Keys and she says, people are coming to me and they're saying that I'm trans. He even says to her, this is interesting, he says, I heard it too. He was never in the police academy. Keys had nothing to do with the police academy. So Keys is hearing it for the first time in the Metra station house, miles away from the police academy. Then on top of that, she says to Keys, this is what's happening. When I go into the locker room, they're talking about me. And in fact, there's a second dissemination of a picture, another bathing
We
suit
just want to
picture.
stick with October 25th. We're
That's
just
October.
trying to drill it down.
That's October, Judge. When she complains in October, right, is in my brief, I make clear, I describe the interaction with Sergeant Keys, and then I explain why this interaction matters and why we're not time barred. And I explain that she says that yet there's another bathing suit picture being circulated, this time in the Metra station house, not in the police academy.
Maybe you don't understand my question, so let me try to rephrase it. One of the things that we have to kind of work through is when was, even before we get to the continuing violation doctrine and whether that's applicable, you're making the representation that we should start at least the clock at October 25th, 2018.
Correct.
And so what I'm trying to elicit from you is what would have qualified that email that was sent to be a disclosure of medical information?
Because she is now being told by people with whom she works that they believe she's trans, that they've heard that she's trans. And
So is the argument is that there was a disclosure from Keys?
no, we don't know.
Okay.
But the disclosures in October are in the Metra station house. But those
You don't
people
understand.
were not at the police academy. There were a few who had a connection, like Sergeant Klima to his daughter. So first we have the disclosure. Then we have the hostile work environment in the Metra station house. So we have both occurring in the Metra station house.
Mr. Cooper, before you did say rebuttal time. Can I ask you one question?
Oh, please.
Okay. It's what in the world is the explanation for your client leaving the Facebook group 45 minutes after the deposition ended?
That's a huge problem. And I'm not going to deny that. That is a huge problem. The only thing that helps her just a little bit, because if I were in your position, I would have a bigger problem as a judge looking at that conduct. That was bad. That was wrong. However, Metra and Cook County always had that post. That post. Now, this is before I got involved in the case, and I'm not passing blame to anyone. I'm simply saying that when I came into this case, I realized Metra already had the Facebook post.
Yeah, I think what animates it's not to point out that it's bad. It's in connection with the district court. The district court was understandably quite concerned about that, but it was all connected with the answer that your client gave in the deposition. That, I mean, look, to your credit, in your brief, you say, you know, the plaintiff understands legitimate concerns about her response. I mean, the response is very problematic.
Oh yeah, I'm not
Problematic enough that the district court called it perjury, found it to be perjury.
Judge, again, there's a conflation of post and text. So, for instance, and WhatsApp is the best example. Many people would define WhatsApp as social media. WhatsApp, in reality, isn't social media. It's simply the same texting you have through Verizon or T-Mobile, except that WhatsApp allows you to post updates. Arguably, that makes it somewhat of a postage
But
expedient.
how is any of that though? I understand what you're saying, but how is any of that responsive to what's on appeal? I mean, the district court made a finding that your client made an intentional and knowing false statement in her deposition, and then the district court was equally troubled by what happened within an hour after the deposition ended. That's part of the debate. It's not all of it. I mean, the questions Judge Pryor were asking you are part of it too, but it's a pretty significant part of the sanction, the dismissal that was the sanction.
I agree. Where I think I can make a plausible argument that the case should be reversed is in connection with living in stealth. So Judge Kendall had concerns about many things that Officer Arriaga said. Okay. And among those things was that she kept her trans status private. And Mr. Goins in his briefs, I don't know if he's here, makes clear, hey, you can't tell other trans people, you can't tell anyone. And what I'm saying is simply that's not realistic. She has to tell someone. There are people who knew she was trans in the beginning. And the way I see it, the district court hit her over the head because she said she's living in stealth, and the district court, unlike in the Grimes case, where the Grimes case basically said, yeah, living in stealth makes sense. I mean, but Judge Kendall's sense was, no, the science behind it is just not good enough where the court can recognize that that's a legitimate lifestyle.
I think there's another. Judge Kendall, if memory serves, was also saying you can't have it both ways. You can't. It's one thing to say you're living in stealth, and it's another thing to be telling a lot of people that you're transgender.
But shouldn't you be able to tell people within the group? That's why I use the example of the Coptic Christians. All right, so they get together and they worship God. And I'm sorry, I made reference to
I know the point
Jewish as well as Christianity. But we see throughout history people practicing Judaism or Christianity amongst themselves. And we see, again, I bring up slavery because there are people in the evening teaching each other how to read. Do they know who they are? If someone goes to Alcoholics Anonymous, right? And I'm not trying to
I understand
be
your point. You saved actually 12 minutes for rebuttal.
Yeah, okay.
And we've
I'll
chipped
sit
into
down.
that a little bit. Well, you don't have to sit down. I just want to make you aware of where you're at on the clock.
All right, but if Your Honor has another question, I'll stay.
Okay.
I have one more question that I
Yeah.
just need clarity on before the other side gets up. Are you raising an equal protection claim?
Your Honor, I'm embarrassed. I would have to look at the complaint. My recollection is that there isn't one.
There is not one?
Yeah, that's my recollection. But again, this case is so old. I've been preparing, but I just didn't run that through my brain.
I think the answer is no. I mean,
Yeah.
you can look at I shouldn't answer that. You should answer that.
Well,
But
I
I'm
don't
looking
think
right at
so.
the
I just don't want to make any mistakes. But I do, in the brief, talk about substantial or substantive due process connected to, bodily integrity. But the
That's
reality
right.
is there's no property interest. The Lanier case from 1997 sort of opened the door, but I'm not going in that direction.
Okay. It wasn't clear.
I just don't ever want to say no when I'm in front of the Seventh Circuit and I'm wrong. All
Okay.
right, it's part of being in the military, as Judge Kolar would probably agree.
All right, let's hear from your adversary and we'll call you back up. Okay, very well. All right, Ms. Kane, nice to see you.
Everyone. Thank you. May it please the court. I'm Carolyn Kane and I represent the Sheriff's Office defendants. In short, the district court judgment should be affirmed for 3 reasons. First, the conduct of the Sheriff's Office does not shock the conscience. Second, Arriaga's transgender status was not private medical information. And third, the Sheriff's Office was not deliberately indifferent. I want to start with our argument that the district court correctly found that the Sheriff's Office did not shock the conscience.
Can I, and I
Sure.
apologize for doing it, can I interrupt you at the beginning just to
Yes.
kind of level set the playing field?
Sure.
Do you agree that the complaint doesn't have a Title VII claim in it? right? The complaint doesn't have an equal protection claim in it. The complaint has a state law claim in it, and it otherwise has claims in the name of the 14th Amendment substantive due process doctrine. Do you
Agreed.
agree with that?
I agree with that.
Okay.
Any other claims from
No.
your perspective?
No,
Okay. Was it ever litigated in the name of equal protection?
no,
It was litigated more in the note, at least as I took away from the briefs, that there's a fundamental right protected by the substantive due process doctrine to avoid a disclosure of private medical information. Here, transgender status.
correct.
Is that correct?
That is correct. So the first point I wanted to make is the conduct doesn't shock the conscience. There's no similar conduct here, similar to the cases cited by the district court judge. And
You're gonna have to speak up for me a little bit.
speak up.
Yes.
Okay, I apologize.
No, it's fine.
There's no similar conduct here analogous to the case law cited by the district court judge to establish that the conduct of the sheriff's office shocked the conscience. Next, my point is that the court correctly granted summary judgment on Arriaga's Monell claim. Arriaga's substantive due process claim was that the sheriff's office failed to establish a policy that would effectively forestall sexual harassment. It's undisputed that there was a policy. The sheriff's office acted pursuant to that policy when they investigated Arriaga's complaint. And further, the evidence doesn't support that there was any widespread practice or that there was a sheriff's office official with final policy-making authority who either made a disclosure or participated in any alleged harassment. And on that point, the court also correctly found that Arriaga's claim against the individual defendants failed because they did not participate or contribute to any act of sexual harassment, nor were they inattentive to Arriaga's complaint. Next, I want to focus on the disclosure made by Sergeant Kamek, the only sheriff's office individual who made a disclosure in this case. This happened before the academy started in April of 2018. Kamek held a staff meeting which included 6 people, and he informed that team that there was a transgender recruit coming and that there were resources and facilities available. Arriaga's identity was disclosed at this meeting for the purpose of ensuring her safety and to make sure that the power test was administered in accordance with her gender identity. Kamek reiterated the confidentiality of this information, and this is undisputed. This limited disclosure is supported by a strong state interest, and therefore the sheriff's office defendants aren't liable under Section 1983.
Should we move to the sanction?
Sure. My colleague Metra is going to speak to the sanctions.
But there's nothing, I guess, in the policy there's no policy that has been presented that was potentially violated by the sheriff's office.
Correct. And one of my last points, Your Honor, is that the sheriff's office cannot and should be held liable for keeping this information private where Arriaga herself failed to do so. This is evidenced by Arriaga's social media activities and her own disclosures to her fellow recruits.
She disclosed to her recruits as well as to some of the staff members as well.
That's true, Your Honor. So she shared with numerous other people, some of which she did not know and who had no obligation to keep this information confidential. I also want to quickly highlight that the district court was correct in finding that the claim against the sheriff's office was time barred. Arriaga knew of the disclosures by June of 2018, and therefore her complaint filed over 2 years later was not timely. Lastly, on the district court's finding...
Counsel from the other side, though, wants to restart the clock at October of 2018. How do we get around that?
October 2018 was after Arriaga had left the academy, which was in August of 2018. And just lastly, on the Civil Rights Act claim, the undisputed facts establish that the sheriff's office did not exclude her from participation in the program. She was accepted, she graduated from the academy, and did well. Further, the sheriff's office did not deny her the benefits of the program or subject her to any form of discrimination. And lastly, The
It
civil
actually
rights.
looked to me, I mean, maybe my impression's wrong. It looked to me like she was performing as a successful officer the moment she walked out the door.
That's true, Your Honor. And Civil Rights Act claims require a showing of deliberate indifference. For the reasons I already touched on, the undisputed facts establish that the Sheriff's Office was not deliberately indifferent. If there are no additional questions for me, I just want to thank you for your consideration of our argument, and for the reasons set forth in our brief, we respectfully ask this court to affirm the district court's summary judgment. Thank you.
Thank you, Ms. Keene.
Thank you.
Okay, Mr. Moore, nice to see you. You represent Metra, right?
Yes, Your Honors. Represent Metra as well as former Chief of Police Joseph Perez.
Okay.
May it please the court, I intend to start with the sanctions issue unless you would like me to start with another topic. The district court did not abuse its discretion by dismissing plaintiff's entire case for perjury and other misconduct. Whether and to what extent plaintiff kept her trans status private was the central issue in the case. Plaintiff's complaint alleges that at all times she sought to keep her transgender status private. Plaintiff initially objected to producing any social media on the matter. At her deposition, she was asked, "Have you searched your Facebook and Instagram accounts for documents in this case?" And she said no, which shows that the social media was not produced before her deposition. She was also asked, prior to May of 2018, "Have you ever posted on your Facebook or your social media anything that would have disclosed your status as a trans woman?" Plaintiff testified without qualification, no. The district court found this was perjury because after plaintiff's deposition, defendants discovered that plaintiff had in fact repeatedly disclosed her trans status online. For example, on April 10, 2018, 1 month before the academy started, and the same day she disclosed her status to Metra recruit Paige Visnovac, plaintiff posted in a Facebook group named My Trans Life, stating, quote, "Been in transition for 4 years now, just got accepted to the academy," and included a photograph of herself. Plaintiff knew that the post could be copied and redistributed, and she had not produced it before her deposition. And we know plaintiff willfully misled defendants in the court because 45 minutes after her deposition, she went on to Facebook and removed herself from the group.
So counsel, assuming we're in agreement that that's problematic, maybe even that it rises to perjury, talk to me about the decision to take the ultimate step of dismissing the case, right? You do have to consider lesser sanctions, and is there enough of that consideration in the record?
The district court judge was very thoughtful in her decision on sanctions. It was consistent with the law. It was supported by the facts. And it was clear that after months and months of trying to get the social media, then taking a deposition, then having to file motions to compel, plaintiff was trying to hide something that went to the core of the case. And when anything goes to the core of the case and you commit perjury on it, you have given up your right to litigate the claim. Now, if this court agrees that the district court did not abuse her discretion in sanctioning plaintiff, it can affirm for this reason alone. Now, turning to the disclosure claim, the record establishes a single disclosure by Metra. That's when Metra sent the medical authorization form that said it was safe for plaintiff to take the power test, the physical agility test, to the academy, and that form, completed by a doctor, disclosed her trans status. There's no evidence in the record that Chief Perez or Deputy Chief Reggio disclosed plaintiff's trans status to anyone. And because of that, before I get to that, plaintiff speculates a lot about who may have said what, but there's no evidence that Perez or Reggio told anyone. And so when we're looking at the single disclosure, Plaintiff consented to it by signing the consent form. She agrees in her brief at page 32 that sharing the form for purposes of the power test was a legitimate government purpose. And for all the reasons that we've discussed, plaintiff didn't keep her trans status private, given her online disclosures and disclosures to recruits. Now, in terms of the alleged October 2018 disclosure, there was no such disclosure. At that time, plaintiff did raise a complaint. But what's key to a Monell claim is that the person who made the disclosure has to be acting under the color of state law. They allege that that was Perez. We disagree that he was acting under color of state law, and there's no evidence that he disclosed it to anyone. It's just secondhand rumors about people who were not acting under color of state law under the Monell analysis. Additionally, when you look at the claims against Chief Perez in his individual capacity, they have to show that he personally participated, and they have not. Then switching to the
So you don't
substantive...
think there's any traction with the notion that there were already rumors that Perez says basically when he comes in, there are rumors going around. Everybody knows. That's not a disclosure.
That's not a disclosure. That would go to a hostile work environment claim that was not pled. Your honors are correct that there was no equal protection clause raised in the complaint. It wasn't briefed at summary judgment. They don't cite cases in their appellate court briefs on that topic. And even if they did, there can't be employer liability for coworker harassment if the employer took reasonable steps in response, which they did. So think about what happens in October. October 5th, before the alleged October disclosure, October 5th, Deputy Chief Reggio reaches out to plaintiff and asks, how's training going? Because he did know that things had happened at the academy. She said, everything is great. October 25th is when she reported the secondhand claims. Perez and Reggio try to meet with her immediately on October 30th, and she cancels the meeting. Then Perez emails her on November 1st, the next day, and says, we need to meet. I need specifics so we can investigate. He also reaches out to Metra's EEO department to make sure that there's anti-trans harassment training. Then on November 16th, when plaintiff finally meets with Reggio and Perez, she refuses to identify specific perpetrators. Then next, on December 17th, Reggio follows up with her again and asks her, how's everything going? And she writes back, quote, everything has been going good. I honestly haven't heard anything lately. I appreciate you checking in. And she never reported any additional concerns to Reggio, Perez, or Metra's EEO office. In fact, 9 months later, in September, she posted on Facebook that working at Metra is, quote, awesome.
Yeah, Mr. Moore, you can wind down. Why don't you leave us with a concluding thought, and we'll go back to Mr. Cooper.
Just very quickly on the Illinois Civil Rights Act claim, Your Honor, the court correctly found that Metra's responses were reasonable under that law. In plaintiff's new argument raised only in the reply brief about Sangamon County Sheriff's Office versus the Illinois Human Rights Commission and strict liability was waived. In her summary judgment brief and in her opening appellate brief, she says that under the Illinois Civil Rights Act, the inquiry is, among others, whether reasonable care or steps were taken by the employer. That they've waived that argument, and it's incorrect. If you have no other questions, thank you for your time.
Mr. Moore, thanks to you. Mr. Cooper, you have a...
I'll go fast. We didn't waive the argument. We argued that the Illinois Civil Rights Act does what Title VII does. It carries us to the last day of the academy, which was on or about August 27, 2018. So there was conduct right through the last day of the academy that we averred 42 times in our complaint that she was subjected to a hostile work environment. So
yeah, it is. I'll just say that it's a bit of a misfit. We just don't see it very often. I can say that with 100% confidence. This substantive due process doctrine being used to press a hostile work environment claim. We see a lot with the employment discrimination statutes.
Your Honor, it was never the intent to go that route. Otherwise, the whole point of the ICRA,
I mean, I don't know how you can say that. It's all over the complaint.
because you have the Illinois civil rights count all by itself. So going back to your question, Judge, your first questions, if we didn't have a disclosure in October, we still had the hostile work environment.
Where is the hostile work environment claim? I asked you, what are the claims you've raised?
Okay, so she describes, I used one example of the locker room, right? I'd have to go through the brief to give more examples. But I lay out in the brief everything that she says happened after July 20th. Okay, and I think I thought I did a good job of doing that. So I'm saying if we don't have disclosure, we still have hostile work environment. I'm also saying, Judge Scudder, that the ICRA claim, that is a hostile work environment claim, as well as a whole lot of everything else. It's far more expansive than Title VII. Am I out of time?
Yeah, we understand your position. We appreciate it. Was there one final quick thought you want to get out?
Yeah, Your Honor, she communicated in private groups with other transgender people. All right, these sites were not open to the
These are
public.
the social media communications.
They were among other transgender people communicating with each other. Thank you, everyone. I appreciate it.
Okay. Mr. Cooper, thanks to you. Ms. Kane, Mr. Moore, your colleague as well, will take the appeal under advisement. Okay, as everyone's getting situated, we'll call the second appeal of the morning. That comes in case number 242806, Anna Bernal versus Kohl's Corporation. Mr. Bott,
Yes.
nice to see you. You may begin.
Good morning, Your Honors, and may it please the Court. Kieran Bott for Petitioner's Appellants. This Court should reverse the District Court based on straightforward application of contract law principles, which are consistent with this Court's decision in Walrich versus Samsung. Because the District Court relied on Walrich to deny the motion to compel, I think it's a fair place to start. In Walrich, my friend Mr. Dvoretsky, on behalf of Samsung, made the winning argument that whether a defendant refused to arbitrate turned on whether the forum, there like here AAA, determined that some action from the defendant was necessary in order for the arbitrations to proceed. In that case, the AAA determined that Samsung was not required to pay fees for the arbitrations to proceed, and courts must defer to that determination. As Mr. Dvoretsky said during oral argument in Walrich, the parties there, quote, agreed to commit fee questions to the AAA under the AAA's rules. The dispute there thus came down to, quote, whether the AAA applied its rules and determined that Samsung violated the rules by declining to pay fees, and that its decision not to pay fees was a refusal to arbitrate. And according to Mr. Dvoretsky, Samsung prevailed there because the simple answer to that question was no. In other words, in Walrich, Samsung's refusal to pay fees was not a breach of the contract because that's what the contract said. The parties delegated fee disputes to the AAA. The AAA's rules said the arbitrations could proceed if the consumers advanced the fees. The AAA applied those rules, and the court had no authority to circumvent that conclusion. Here, the facts are the opposite and require reversal under that very same logic. The parties agreed to resolve disputes only by final and binding bilateral arbitration. That's at SA 79. The AAA's rules, Rule 12 in particular, expressly defines the business's registration of its arbitration clause as a condition precedent to arbitration. That's at SA 202. This dispute thus comes down to whether the AAA applied its rules and determined that Kohl's violated the rules by declining to register its agreement and that its decision not to register the agreement was a refusal to arbitrate. The simple answer to those questions here is yes, and that follows from the AAA's communications to the parties in this case. On June 7th of 2023, the AAA advised that Kohl's, quote, failed to comply with the AAA's consumer arbitration rules. That, quote, in order for the AAA to consider accepting these disputes, as well as disputes going forward, Kohl's must advise the AAA of its intention to comply, and, quote, at minimum, must register its arbitration clause.
I mean, doesn't Rule 12 by its terms contemplate this scenario?
It does, Your Honor, and it doesn't give the AAA any discretion to do other than what it did in this case, which is to find first that Kohl's had violated its rules by not submitting its arbitration agreement for registration, and that if Kohl's does not comply, and this is at SA 181,
Right.
absent a court order, the AAA will be unable to provide arbitration administration. The parties all agree here that Kohl's then refused to comply with Rule 12, refused to register its agreement, and the AAA confirmed weeks later that that was the reason it was declining arbitration administration. And appellants submit here that the court must defer to those conclusions as well, unlike in Walrich.
But did the American Arbitration Association have the discretion to apply the consumer arbitration rules?
Your Honor, I think there's a disagreement between the parties on this. I do agree that the AAA had discretion about whether to apply the consumer arbitration rules as a set of rules. And we cite in our papers the Jacobs case, in which the Second Circuit made a determination about which set of rules applies, the consumer arbitration rules or the commercial arbitration rules, based on a dispute between the parties in that case over which set applied. And if you look at Rule 1E of the AAA consumer arbitration rules, and you look at the preamble to the AAA consumer arbitration rules, it's very clear that the discretion AAA has to apply or not apply the consumer arbitration rules is the discretion to apply or not apply that set of rules. And I think we gave the hypothetical in our papers that certainly the AAA couldn't order the parties to resolve their disputes by trial by combat in lieu of a Rule 32 hearing. It does not mean that AAA has a discretion to pick and choose which rules, which the parties agreed to, which specific individual rules would apply. And I think there's a disagreement between the parties on that.
So if they decided to apply the consumer arbitration rules, and I want to, you asked us to look at the supplemental appendix 195, you directed us to 202, but I wanted to back up for a minute to 196 of the arbitration rules, when the parties agree to arbitrate, and where the consumer arbitration rules kind of walk through what initiates an arbitration. So is it the contention that the arbitration, looking at the consumer arbitration rules that AAA has decided to apply, was never started?
Yes. In a sense, the initiation of the demands, so the filing of the demands, initiates the process of arbitration.
Mm-hmm.
But
is that in line with the consumer arbitration rules?
I believe it is, yes, Your Honor.
Okay.
But here, I think that the distinction between this case and Walrich.
I'm not asking that. I'm asking whether or not in this case was the arbitration initiated.
Well, in the sense that the petitioners filed demands, they sought to initiate the arbitrations. I don't think that AAA ever actually exercised its authority to then go through the Rule 4 requirements in order to determine whether those demands were sufficient, because Kohl's refused to register its arbitration agreement. So to the extent that one could say that the arbitrations had been initiated, it's solely by the submission of the demand itself and not by the AAA's then subsequent action, administrative actions, because Kohl's refusal to register its agreement barred AAA from taking that action, as it set forth in the communications to the parties.
Where are you getting in the rules AAA would have been barred from exercising its discretion not to enforce Rule 12 and to go forward with the arbitration since the agreement was provided by your clients?
The Rule 12 itself, I believe it's SA 202, Judge Kohler, says that the American Arbitration Administration will decline administration if the business does not register its arbitration agreement. And I can find the specific language when I return to the podium for rebuttal, but I think it's important to note that any arbitral forum, its authority derives from the consent of the parties. And the parties in this case agreed to a set of rules in which a condition precedent to arbitration was the business's registration. Unlike in Walrich, we don't have a situation where the consumers could have done something. In fact, the consumers did attach their arbitration agreement to their demands, but the AAA said that wasn't enough. What needs to happen for this arbitration to proceed is that Kohl's needs to register its arbitration agreement. Kohl's needs to pay the associated expedited review fees and the original review fees for that registration. And so it would have been anathema for the AAA to just decide, well, we're going to ignore Rule 12 and just proceed with this anyways. That is, in fact, why, in my estimation, they advised the parties that in order for arbitrations to proceed, there needed to be some action from Kohl's. And that's what distinguishes this case from Walrich. It's a very different circumstance. And you can imagine very easily a hypothetical where the shoe is on the other foot. So say a claimant wanted to avoid arbitration. They then submit in lieu of the Rule 2 demand with the facts and the contact information, scrawl on a piece of yellow legal paper that says, I'd rather be in court. AAA comes back and says, well, hold on a second, we can't administer this arbitration unless you file a demand in compliance with Rule 2. Kohl's might even offer, we'll file the demand in light of the parties' communications with one another. AAA says no. The consumer or the claimant says, I'm not going to submit a new demand. And the AAA closes the administration, declines administration. In that instance, it cannot possibly be that if the consumer then runs to court and tries to assert their claim in court, that Kohl's loses the Section 4 right to compel arbitration. And I would submit to your honors that that's essentially what happened here. In this case, we've got a situation where Kohl's deliberately refused to register its agreement after being told that it was a violation of AAA's rules, did so in order to facilitate what we've described in our papers as a bad faith change in the terms in the middle of a dispute. The cases that Kohl cites on this front are simply not distinguishable from Pruitt, from Peleg, and the cases that we've relied on the implied covenant. What happened is essentially there was a notices of dispute filed in December 2022, 5 months of good faith negotiation. Kohl's decided to implement a strategy to change the procedures that applied to this dispute, and then used that as cover in order to refuse to arbitrate at the AAA.
Has any circuit court, to your knowledge, in a published opinion, so I'm not talking about state courts, I'm not talking about lower, has any circuit court in a published precedential opinion taken a position contrary to the one this court adopted in Walrich?
I don't think so, Your Honor. I don't think there are published opinions on that front, but I'd submit that.
So then a lot of it comes down to the point you started with, this is not Walrich.
That's right, and I think that that's dispositive in this case. I reserve 4 minutes for rebuttal. If the court has any additional questions, I'm happy to answer them. Otherwise, I'll reserve my time.
Yeah, you're welcome to.
Thank you.
Very well. Mr. Dvoretsky, nice to see you.
Good morning, Your Honors. May it please the Court. Shai Dvoretsky for Respondents, Appellees, Kohl's Corporation, and Kohl's, Inc. This case is on all fours with Walrich as the district court held below. As in Walrich, 4 things are true here. First, the arbitration agreement here incorporates the AAA rules. Second, as in Walrich, those rules give the AAA the discretion to apply or not apply any of its rules. And as this court described that proposition in Walrich, that's not about applying the rules as a whole, that is about applying or not applying any of the individual rules. Third, as in Walrich, those rules contemplate the scenario where one party refuses to satisfy a condition precedent for arbitrating. In Walrich, that was paying fees. Here, it's registering the agreement. Fourth, as in Walrich, the AAA exercised its delegated authority to interpret and apply its rules when it closed the arbitration proceedings. Therefore, as in Walrich, arbitration was complete, and the court doesn't have the authority to disturb the AAA's judgment.
Counsel,
Judge.
So there are 4 things that might be similar to Walrich, but there's some differences here. In Walrich, the consumers had a way to make the arbitration proceed, namely advance the fees. are you disputing that's not present here? There's nothing the consumers could have done to have the arbitration proceed. And how is that not different than Walridge?
2 points in response to that, Judge Kohler. One, the situation that you've just described was the same in Hogue, where the AAA didn't give the consumers the opportunity to advance the fees. This court nevertheless applied Walridge and held that it was controlling to summarily reverse the district court there. Second, the key point is not whether the consumers had that option or not. Walridge simply didn't turn on that. The key point is that the parties here bargained for the AAA's application or discretion not to apply its own rules. And here, in both situations, the AAA had a rule that spelled out the consequences if a party didn't satisfy a condition precedent. And again, the AAA exercised its discretion to apply that. Well, the Second Circuit's decision. I'm sorry.
Go ahead. You can finish.
Well, the Second Circuit's recent decision in Frazier, to get to Judge Scudder's question about other circuits' authority, also confirms all of this. What the Second Circuit explained there was that a party's decision not to abide by the procedural determinations of an arbitrator is ordinarily not a refusal to arbitrate under Section 4. What that is, in the Second Circuit's words, is an intra-arbitration delinquency that arbitral bodies, like JAMS there and the AAA here, are empowered to manage. And so what the Second Circuit correctly said there was that the arbitrator has tools. It has discretion under the AAA rules that the parties bargained for. The arbitrator has tools available to it to resolve the issues as it sees fit, quote, even if that ultimately means terminating the arbitrations.
Now, this might kind of dovetail, and you're probably going to rely on Frazier for this, but why wouldn't this just be somewhat of an, I don't want to call it an in run around Section 4 by Cole's failure to file the registration agreement, so that when Coles wants to go to arbitration, they file the registration, and when they want versus litigate, and withholding it is just kind of a way to get around Section 4.
So 2 points, Judge Pryor. First, again, I come back to AAA's discretion. The AAA has discretion to apply or not apply its own rules. It could waive the registration requirement if it wanted to. That's not what it did here. Instead, it applied the rules and terminated the arbitration.
So tell me the same question Judge Scudder asked. What rule would have I'm sorry, that was Judge Kolar, that would have permitted the arbitrators not to apply the requirement of the registration?
So it's the general grant of discretion to the AAA, that the AAA has the discretion to apply or not apply its rules, and it could choose not to apply the registration requirement and to proceed to the merits of the arbitration in that situation. I think.
Go ahead, finish your thought. No, go ahead. I'll follow you. Go ahead.
I was just to complete my answer to Judge Pryor on Section 4. Section 4 is about making sure that the parties go to the arbitration. If a party brings a claim in court that belongs in arbitration, Section 4 empowers the court to direct the parties, go to the arbitration and follow the arbitral rules. And then this brings us back to Frazier. Once the parties are before the arbitration, then we have an intra-arbitration issue, and that is what the AAA is empowered to adjudicate. If a court were to get involved in that, there would be no difference between interpreting and applying the AAA's rules here, which a court can't do on the one hand, and on the other hand, resolving a discovery dispute that comes up in arbitration. Again, Frazier gives this example. What if a party refuses to comply with a discovery order of an arbitrator, and then that party runs to court and says, my counterparty is refusing to arbitrate. They are not following the arbitrator's instructions. A court couldn't do that, not as a matter of Section 4 and not as a matter of sound judicial administration, and there's no sensible dividing line between that situation and this one.
I mean, I think what your argument comes down to, and don't let me put words in your mouth, is what you're saying is, look, it's all the fruit of contract. It's all the product of a contract and agreement. And the parties could negotiate their primary contract different. They could negotiate terms and conditions that sit on top of the AAA rules that would delineate what are allowable reasons for not registering an agreement, etc. It just didn't happen here, and therefore you apply it as written. But Mr. Bott, and how do you respond to their point that, geez, this sure looks mechanical, the obligation to register an agreement just looks like the notice of intent to arbitrate is lodged. There's a mechanical registration process that happens to kind of get the wheels of the process turning. And for Coles to have just refused to submit the agreement, it just makes all this look like a phantom. It makes it all look illusory. What's your response to that?
So a couple of points on that. One on the illusory point, but I also think it's important to understand the context of how all of this came up. The reason that Coles didn't register the agreement here, didn't register the AAA agreement, is that it was no longer the operative arbitration agreement. Coles has registered its arbitration agreement with NAM, which is the currently operative agreement, but no, it did not register the agreement with the AAA because registering an agreement is holding out to the public in a public-facing website that this is the arbitration agreement that a company will arbitrate under.
So you guys said the other one was withdrawn or superseded or displaced. We have a new one.
Right. So that's the context. As far as the legal argument that the other side makes that this is an illusory contract, first, it's not an illusory contract because, again, as a matter of contractual terms, this is not an unfettered promise to arbitrate. It's a promise to arbitrate under the AAA rules, including the consequences for noncompliance. You can look at any particular incident of noncompliance and say, you can think that's either mechanical or insignificant or significant. But again, it's not the business of courts to make that determination. If a party doesn't comply with a condition precedent for arbitration, the rules set out the consequences for that. And given the AAA's discretion, it's not like there's no risk to the party in non-complying. You don't know how the arbitrator or the arbitral body is going to respond to that. It might exercise its discretion not to apply the rules or to apply some different consequence than what's in the rules. So it's not an illusory promise because there is real risk, and it's in the hands of a third party, the arbitral body, as to what's going to happen in that situation.
Can you, I want to ask you the same question I asked Mr. Bott about the state of case law around the country. What's your understanding?
No circuit court has disagreed with Walrich. In fact, as the Second Circuit recently explained, the circuit consensus on these issues is unanimous, and the Second Circuit expounded upon Walrich with some very helpful language.
That's the Judge Lynch opinion in Frazier?
That's right, Judge Lynch.
In counsel, the Frazier opinion, that was about fees as well, correct?
It was about fees, but again, the key language there is really about conditions precedent to arbitration, and there is no principled basis, there's no reasoned basis to distinguish between the payment of fees on the one hand and any other condition precedent to arbitration.
Wait, isn't one principled basis that the payment of fees doesn't bar the initiation of the arbitration, and that the failure to register means that you never proceeded through arbitration in the first place?
I don't think that's correct. The failure to register doesn't bar the initiation of arbitration either, because the AAA can, again, waive that requirement. And my understanding in practice is that they sometimes do. So the AAA could have chosen to proceed to the merits. It didn't choose to. The payment of fees, if anything, I would think is more of a practical bar to proceeding with the arbitration because the AAA isn't going to work for free. And so either way, you have a condition precedent and you have a consequence under the rules that the AAA has discretion to apply.
So is that effectively saying that they'd say, look, as a factual matter, you didn't register, but we're going to deem that acting in bad faith, or we're going to, maybe not bad faith, but we're going to just waive that requirement and we're going to go forward anyway on the demand to arbitrate?
I don't think there was anything in the rules that would constrain the AAA's delegated discretion to do that if it wanted to do that. The key point here is that that's not what it chose to do. It sent a letter to the parties saying we are closing our files on these matters. And as far as the arbitration having been initiated, the AAA did assign case numbers to these files. It did start to process them in that way, and then it terminated them. As in Walrich, where the fees weren't paid, that means that the arbitration pursuant to the parties' agreement was complete.
Is it your position that AAA has the discretion to apply or not apply Rule 12?
Yes. And my friend on the other side argues that the discretion has to be understood as applying the AAA consumer rules as a whole or to apply different rules. 2 points on that. One, that's not what Walrich said. Walrich said that under the AAA rules, the AAA has the discretion to apply or not to apply any of its rules, including rules that cover administrative fees. That's 106 F4th at 613. So that's not how Walrich described the rules. It's also not how the AAA itself describes its discretion to apply its rules. This is at 2 SA 192. It says the AAA has the discretion to apply.
192.
Hold on, say that again.
2 SA 192.
I can't flip that fast. I'm there.
It says the AAA has the discretion to apply or not to apply the consumer arbitration rules, and the parties are to bring any disputes concerning the application or non-application of the rules to the attention of the arbitrator. So the rules there are saying that the parties can bring any disputes concerning the application or non-application of particular rules. You wouldn't go to the arbitrator and have your dispute be arbitrator, the entire set of rules that you are applying, that you are operating under, is the wrong set of rules. This is talking about particular rules.
Is there a limiting principle, if any?
I'm sorry?
Is there a limiting principle, if any, that we can glean from Walrich?
I think the limiting principle really comes down to whether you could imagine a different set of rules that perhaps constrained what the arbitrator could or couldn't do. But on this set of rules, I think if you have a failure to comply with a condition precedent, and if the arbitral body has addressed that consistent with its authority under the rules, then I think the principle is that the arbitration has been had and there isn't a role for the court to intervene in that situation. I think if you deviated from that principle, then you would have a problem with not being able to find a limiting principle, because how could you decide when a court is or is not allowed to start reading and interpreting arbitral rules, which again would both interfere with sound judicial administration by creating this sort of ping pong between courts and arbitrators in a series of interlocutory arbitral appeals, and it would really defeat the purpose of arbitration, which is to have resolution pursuant to agreed upon contractual terms, and not to involve the judicial process in the way that you do if you resolve your disputes in court.
But counsel, those contractual terms, and Judge Scudder brought up illusory in his question, and is your argument that it's not illusory hinge essentially on the AAA not following its rules or exercising the discretion to ignore Rule 12? Because otherwise, you have an on and off switch for arbitration that claimants don't have.
So 2 points. First, I wouldn't say that it's not following the rules when what they are following is the rule that lets them exercise discretion. There are all sorts of reasons why they might properly
excuse
exercise
non-compliance, right?
Right. Second, though, even if you think that Coles has this unilateral on and off switch, I disagree with that characterization, but even if you think that, this is still not an illusory promise, because at that point it's an option contract. Either Coles can choose to arbitrate, that's a real promise supported by consideration, or there's a forum selection clause in this situation, in this contract. If the parties don't arbitrate, then they agree to resolve their disputes in Wisconsin courts. That's also supported by consideration. And in all events, Coles agrees to let customers shop in its stores and on its websites. So no matter how you look at it, this isn't an illusory promise. There's consideration either way this goes.
Okay, any final thought you want to leave us with?
We ask you to affirm the district court under Walrich.
Okay.
Thank you.
Very well. You're welcome.
Your Honors, if I may start with just the contractual text here to respond to the final point that Mr. Dvoretsky made. And I think it's important that the court ground itself in the text of the actual contract. I'm looking at 1 SA 79. In capital and bolded letters, you and Coles agree that any dispute, and then it goes down a little bit, shall be resolved only by final and binding bilateral arbitration. That means arbitration, not arbitration or court. And I think it's confirmed on the following page, SA 80, Section F, in the section titled Waiver of Jury Trial. You and Coles waive any rights to go to court and have a trial in front of a judge or jury. You and Coles are instead choosing to have all disputes resolved by arbitration. So I think it's just a farcical premise that Kohl's, by incorporating the AAA rules and then itself refusing to register its agreement, had the option, contrary to the plain text of the actual contract itself. I also want to focus on Hogue, because I think it's illustrative of the limiting principle that Judge Pryor was asking about. So the court in Hogue actually recognized that there's a distinction between a situation where the AAA simply allows the consumers to advance the fees and to proceed with arbitration and then terminates the files at the end, and a situation where the parties came together to the AAA and asked for a suspension in the arbitration. The AAA declined to do that, but said you can refile if you want to refile later on. I think the fact that the court noticed that difference is really important here, because essentially, even sort of stipulating to Mr. Dvoretsky's premise about Frazier, that intra-arbitration disputes are just unreviewable by the federal courts, you have the AAA's exercise of discretion here. You have the June 7th, 2023 letter. It's at 2 SA 181, in which the AAA exercises its discretion to say, Kohl's, you have violated the consumer rules by not registering your agreement. If you do not comply, absent court order, we AAA cannot do anything to move forward.
Didn't Sampson do that though, as well, with with its decision not to pay fees in Hogue? I mean, isn't it? It seems substantively awfully similar.
Well, in Hogue, the parties went to AAA together and asked for a suspension of the arbitration so that the parties could resolve their dispute in court. And what the court said was, there's a situation in which the fact that the AAA left open the possibility of additional administration is relevant. It just doesn't apply in this Hogue case because the claimants brought their petition before they refiled their demands. So I think here you have the AAA saying on June 7th of 2023 that absent a court order, AAA would be unable to administer these disputes. And that's important.
Hogue, there was still, I think where Judge Scudder is going, there was still a condition precedent. And that was paying of the fees. They said,
I don't think it was a condition precedent, Your Honor. I don't think it was, because the AAA's rules in Hogue, in this case, in all three cases, in Walrich as well, make clear that the consumers can advance the fees. That was the supplementary rules that were described in the Walrich decision towards the end of the decision. It's very clear that the AAA had the discretion in that circumstance to allow the consumers to advance the fees. They did. And then subsequently, the AAA had another inflection point of discretion in which it could either decide to suspend or terminate the arbitration. So the termination in that case had independent significance because the consumers asked, can you please suspend this so that we can go to court and resolve this fee issue? And in response, AAA closed the files. Here, AAA told the parties, Cole is violating the rules. Absent a court order, we can't do anything. And after that, closed the files. And I think that makes all the difference. The fact that the AAA exercised its discretion to find that Coles had violated the rules is what's dispositive in this case. So in Walrich and Frazier, no breach. In this case, breach. And with that, I'd ask that you please reverse the district court's order. Thank you.
Okay, Mr. Bott, thanks to you. Mr. Dvoretsky, thanks to you and to all of your colleagues. We'll take the appeal under advisement. Okay, our third argument of the morning comes in appeal number 24-1503, O'Neill Johnson versus Ryan Edwards and others. Ms. Thompson, nice to see you.
Good morning. Elizabeth Thompson, pro bono counsel on behalf of plaintiff appellant O'Neill Johnson. The district court erred in this case in granting summary judgment in favor of the defendant, and for the reasons in our brief and that I will discuss, we would ask this court to reverse. I want to go through some of the facts because I think it's important in this case where the district court relied on facts that were in dispute and also construed a number of inferences in favor of the defendants when it shouldn't have. On the night of April 21st, 2019, Plaintiff was walking to a bus stop to return home from visiting a friend. At approximately 3 a.m., he encountered 4 to 5 police officers standing around on South Champlain Avenue. One of the police officers, who was standing there smoking a cigar, stated, "Man," and I apologize for my language, "Man, that's that black MFer from 76th Street that got into it with the sergeant." That's not captured on the police body-worn camera. And in fact, when you watch those police body-worn cameras, it's clear that they pick up right in the middle of a conversation. So everything that happened before that is in dispute. But my client testified that that is what was said to him, and at that point, or some point thereafter, the cameras turn on. Plaintiff has a history with the Chicago Police Department. He's been arrested 57 times. He's also sued the Chicago Police Department a number of times. Those facts are not in dispute. At some point during the interaction with the police, their body-worn cameras are turned on. It's clear, like I said, that the interaction began before those cameras are turned on. Those videos, and we have several, show that plaintiff is arguing with the officers. There's no question about that. And the argument is primarily about race. Plaintiff testified that he was very upset in his deposition, that he was very upset about the comment that was made by the sergeant that occurred before the video was turned on. He never makes any threatening gestures. He never moves closer to the crime scene that the officers argue they were attempting to protect. Instead, he says multiple times, and in fact his body language is, "I'm going to go the other way, I'm going the other way, but first I want to give you a piece of my mind about what I'm upset about." Without giving him the opportunity to comply with their demeaning and successive demands that he immediately leave, the officers swoop in and arrest plaintiff. He's put into a squad car, handcuffed and unrestrained by a seatbelt. At that point, he's recklessly driven by defendant Hecker, who, despite having no emergency, and this is shown on the videos, has his lights on, runs several red lights, and drives excessively fast. He then slams on the brakes, throwing plaintiff into the plastic divider as he's handcuffed and unseatbelted. Plaintiff, who had been talking the entire time up to that moment, he screams out in pain and then completely stops talking. The officers don't check on him. They continue driving, and in fact continue driving for 3 minutes without doing anything. Again, these facts are shown on video.
Can I go back to where you started a little bit?
Of course.
And that is, the point you're making about there may have been something said that was picked up on, or wasn't picked up on the recording. But your client was at a crime scene that was being processed in response to a shooting.
He was near a crime scene, yes.
Pretty close.
I think the videos show, I mean, it's hard to tell exactly how many feet, but probably similar to where I am to that wall.
Pretty close. And then he's told multiple times, they're definitely jawing at one another. I think you can watch that on the video, it's clear,
Yes.
But he's told multiple times, "Hey, hit the road."
He is told multiple times and in different ways, walk away, walk backwards.
And it so looks like he intended to get arrested. When I sat there and I watched that, I didn't have any idea he'd been arrested, 30 times or 40 times or some big number of times by CPD. And it doesn't really matter. It's not relevant. What's relevant is what happened here. But
Correct.
It just looked like, is this guy trying to get arrested? What is he doing?
I watched the same videos that you did, and that's not my interpretation of it, and I think that's an inference that may be drawn from the videos that's not appropriate on summary judgment. I can't answer the question of what his intent was because I'm not him. I
But
wasn't in his mind.
looked, there were just a lot of warnings given, a lot of statements given. Hey, move along.
I think it's a fairly chaotic situation, and I think that you have to think about what happened before that. And if we're talking about his intent, I think you have to think about what he went into that situation with, his history with the police.
But I think I can appreciate that as far as what Mr. Johnson, if we accept the facts as presented by Mr. Johnson of how he perceived the officers were engaging with him. Okay? Even if we accept that, and I believe Judge Jenkins said, okay, if I step away from whether or not there was probable cause for disorderly conduct, this is where Judge Scudder is going, is how do we get around, though, that at least there was arguable probable cause if we just take it from the moment the body cameras come on?
Right, and so I think you've hit the nail on the head that the district court said, the question of probable cause is a close one, but I'm deciding this on arguable arguable probable cause, I'm saying that the officers had arguable probable cause and therefore they're entitled to qualified immunity. I think this court has said several times that questions of qualified immunity are not ones that are well resolved on summary judgment. And I think with regard to the arguable probable cause question itself, that he does indicate that he's going to leave. All of this happens very quickly. Those videos that capture the arrest from a number of different angles are all just a couple of minutes long. It all happens very, very quickly. He's told to walk away, to back up. He does back up, and in fact, he's saying, I'm going to go the other way, I'm going to go the other way.
No,
And
he says, I am with Waste Management and I want to go that way.
He does say
he's pointing toward the active crime scene.
He does say that at one point, but then he indicates he's going to go away, he's going to walk away, and in fact starts backing up. And one of the officers, he says, Mr. Johnson says something along the lines of, you can't tell me what to do. And they say, well, then, why are you backing up? So he is complying with their commands. And it's only at the point that he's telling them, like, I am unhappy with what's going on, I'm unhappy with the way that you are treating me, that they swoop in and arrest him. So the arguable probable cause question looks at what was happening in the totality of the circumstances. And in this case, the only thing that was happening was they were telling him to move away. He's moving away. They're still sparring with each other, absolutely. And our argument is that they arrest him based on their displeasure with what he's saying. There is clear case law coming out of this circuit that says you cannot arrest an individual for disorderly conduct for speaking their mind. That is a violation of the First Amendment, and we've cited some of those cases in our brief, but Rooney versus Beiser says probable cause would be lacking, and that's 742 F 3rd 737. Probable cause would be lacking if Rooney had done no more than shout at Beiser. Payne versus Pauley, which is 337 F 3rd 767. It is well settled under Illinois law and was well settled at the time of Payne's arrest, and this is in 2003, that the resistance must be physical. Mere argument will not suffice. In fact, the First Amendment protects even profanity-laden speech directed at police officers. So our position is that there was not even arguable probable cause, or at least there's questions of fact as to whether or not there's arguable probable cause.
But I'm trying to make sure that I'm following, even taking it out of the First Amendment context, that what he was charged with here, though, was reasonable, issued. They're telling him, walk the other way, not only stop speaking. So taking it out of the First Amendment context, but we're needing you to not approach this active crime scene.
Correct.
And he's still moving around in the area.
I think the video shows him walking backwards. He walks backwards maybe 5 steps. He's probably about 5 feet at that point from the closest officer. And again, these are my own inferences from watching the video. And at that point, they continue talking, and then he kind of shifts his weight a little bit, and then they come in and arrest him. So I think he was in the process of complying with those demands, and so that's why we believe, or we are arguing, that there's not arguable probable cause for the wrongful arrest claim. We've also stated, and I really wanted to focus on that claim and also the excessive force claim, because I think those are where
the state created danger.
I'm certainly not abandoning that claim by any means, and I address it in our brief, and I'm happy to answer questions about it, but I think that the wrongful arrest and the excessive force claims are the claims where the district court most clearly erred. And I think with regard to the excessive force claim, what the court did in that claim was said, kind of similar to what it did in the wrongful arrest claim. It said, the question of whether or not defendant Hecker's conduct was reasonable and his force was excessive is not a question that I can answer on summary judgment. However, there's no clearly established case law, so he's entitled to qualified immunity. That was an error, because there is clearly established case law. There's clearly established case law from this circuit in Salinger versus Oaks, 473rd F 3rd 731. That says gratuitous use of force on a handcuffed detainee is a violation of the Constitution. Stockton and Williams are some other cases that we cite in our brief that are Seventh Circuit cases that stand.
What is the force that Officer Hecker applied?
The force that he applied was, he knew that Plaintiff was not seatbelted.
But because this is an excessive force case under the Fourth Amendment, it's objective, right?
Yeah, that's
Okay.
correct, yes. And the way that he drove his car in a manner, first of all, he's not responding to an emergency. There is no reason he needs to be driving in the way that he was driving, which I think that video shows, or at least there's a question of fact, because our client has testified that he was driving excessively fast. He was asked to slow down by plaintiff. He's running red lights. He has his lights on. None of those things are necessary for the situation at hand. He slams on the brakes and throws plaintiff into the divider, which causes him to lose consciousness for several minutes. So that's what the excessive force claim is based on, and there's a robust consensus of persuasive authority in addition to the Seventh Circuit cases that we've just cited that talks more specifically about this type of force where, again, it's the gratuitous use of force on a detained.
That's where I have some concern with the argument. So I think you're referring to the Fourth and Tenth Circuit case law?
Correct,
Yeah,
yes.
it gets more factually analogous for you. That's why you have it in your brief.
Correct.
Okay. But hasn't the Supreme Court, for better or worse, told us that we do need to analyze this at high levels of factual specificity?
Yes, I'm sorry to interrupt you.
No, go ahead.
Yes, I think that's right. I don't think it has to be such a high level that we need to look at, okay, the exact same situation. We do have those cases, and admittedly, they are not from this
Yeah,
circuit.
it doesn't have to be identical. I mean, you have cases like, you have a couple of cases anyway that they've decided, like Hope v. Peltzer or Taylor versus Riojas, but it's a pretty narrow category of what they call obvious constitutional violations.
Correct.
Okay, but I didn't see you arguing that it's just obvious.
Yeah, I mean, I think that on hindsight maybe is something that we should have argued in our brief, and I do
It's a
think
pretty
it probably,
limited category.
Yeah,
I mean,
it is, and so I'm kind of in my rebuttal time here, but
we're gonna give you rebuttal time.
Thank you. Just to address that question, I don't think that it has to be exactly identical, as Your Honor has said, and I think that the case law that we rely on from this circuit does address the issue of when you have a individual who is restrained, in this case in handcuffs, that there is no, and not resisting, right? He was not resisting. He was in the back seat of the car being transported to lockup. He was not resisting. That in those circumstances, any use of force is unnecessary and unconstitutional. So I think those cases, although it would be great if we had a Seventh Circuit case that had the same specificity as the ones that we cite out of circuit, I think those cases are enough that the officer should have known that this was unconstitutional conduct.
Okay, very well. You want to save the rest of your time?
I would like to, thank you.
Okay, you're welcome. Mr. Alperstein, correct? Yep, good morning.
Good morning, Your Honors, and may it please the Court. The District Court's grant of summary judgment to defendants on all of Johnson's claims was correct and should be affirmed. Today, I will focus on the claims of false arrest, excessive force, and delay of medical care, although, of course, I'm happy to answer any questions this Court has on the other claims as well. First, Johnson's false arrest claim fails because the officers had probable cause to arrest him for violating the disorderly conduct ordinance. That ordinance prohibits failing to obey an order of a peace officer where it is reasonable to believe that the order is necessary to protect public health and safety.
What can you just so we can level set on the facts a little bit about? The body cams often will start a little bit late, but are not right at the beginning of some kind of altercation. Ms. Thompson's pointing out something that was said that was racially derogatory, kind of inflammatory at the beginning of the. You're not disputing that we should view the facts in the light most favorable to the plaintiff in this posture, right?
No, of course not, Your Honor.
Including accepting that one.
Yes,
Okay.
that's correct. However, that does not impact the false arrest analysis here. And first, I'd want to point out that Johnson did not argue in the district court or on appeal that the officer's order to leave was not reasonably necessary to protect public health and safety. So any such argument would be waived. Johnson argues, and does today as well, that he was in fact complying with the orders to leave, but was arrested before he could do so. And here, the video evidence conclusively disproves that assertion. The video shows that Johnson was ordered at least 10 times over the course of a full minute, with plenty of time to comply, to leave the area, and he in fact never left. In fact, Johnson did not even turn around at any point to leave, and he gave contradictory verbal indications about whether he intended to leave or intended to proceed into the crime scene. In that case, the officers had probable cause to believe that Johnson was failing to obey their orders to leave, which constitutes disorderly conduct under the ordinance. Alternatively, the officers had probable cause to arrest Johnson for violating Illinois' disorderly conduct statute, which prohibits the creation of a disturbance or a breach of the peace. Illinois courts have held that creating a loud disturbance in the middle of the night in a residential area does constitute disorderly conduct under that statute, and that is exactly what happened here, as we can see from the video footage. The officers are also entitled to qualified immunity on this claim. As Your Honors have mentioned, the Supreme Court has explained that in a false arrest case, the plaintiff must point to precedent establishing with a high level of specificity that the circumstances confronting the officers do not constitute probable cause. Johnson did not even attempt to identify such a case until their reply brief, thereby waiving the argument. But waiver aside, the reply cites cases primarily from Massachusetts and Minnesota. Counsel mentioned Seventh Circuit case as well. But the important point is all of those cases evaluated an entirely different type of criminal offense. Those cases evaluated disorderly conduct statutes prohibiting, I believe the language, something like noisy, boisterous behavior, and those cases talked about whether speech alone can violate that provision. Here, the disorderly conduct ordinance prohibits conduct. It prohibits failing to obey an order of a peace officer. The order was for Johnson to leave the area. He did not leave the area. And so those cases do not even apply to the type of crime and the type of conduct at issue here. They certainly do not clearly establish that the officers did not have probable cause to arrest Johnson. Summary judgment on Johnson's excessive force claim was also proper because Officer Hecker's conduct did not violate the Constitution. Where all the facts necessary for resolving a claim are undisputed, this court determines objective reasonableness as a matter of law. Here, all of the relevant facts... Are there
any facts left for a jury to decide?
No, Your Honor. All of the facts here are either depicted on the dashcam video or are uncontested by the parties. So, for example, Johnson claims that Officer Hecker was speeding. The video does not indicate whether that's true or not, but for purposes of summary judgment, we have accepted that he was exceeding the speed limit. And everything else, all other facts about the manner in which Officer Hecker drove and the manner in which he applied the brakes are shown on the video. The video shows that Officer Hecker did not swerve or drive erratically during the trip, and even with the braking, the video belies any assertion that there was a slamming of the brakes or a sudden jolting stop. You can see in the video that...
There's one aspect of this that's troubled me a little bit, okay? And that is the failure to ensure he's seat belted. Okay, how does that work into the legal analysis that you're advocating for? We know, as a matter of fact, he wasn't seat belted. It's not his responsibility to seat belt himself. He's pushing back on whether he should be seat belted or not. But the fact of the matter is, the squad car leaves, the radio car leaves the scene with him not seat belted. Mm-hmm. How does that play into this, if at all?
Well, the failure to buckle Johnson's seatbelt, or really Johnson's refusal to allow the officers to buckle his seatbelt, I think is argued more with regard to the state-created danger claim, but on excessive force, I do think that is... But
that's the situation. The reason why you're correct, the fair inference, at least viewing the facts in the light most favorable to Mr. Johnson, okay? The only reason he's able, when the brakes go on, to fly forward and cut his lip open on that, whatever it is, the glass shield or the plexiglass or whatever they call it, is because he's not seat belted. Now, I would think it's probably highly unlikely that he would injure himself in the same way if he was seat belted. Is that not a fair inference at summary judgment?
Yes, I think that's a fair inference.
The reason, yes, he pushed back on the seat belting, but the police officers, don't they bear a responsibility to seat belt the guy?
They do, and Officer Hecker was reprimanded for not ensuring that the seatbelt was fastened. And certainly, Officer Hecker knew when he was driving that Johnson was not wearing a seatbelt.
And you
that
knew
is
that
part
you
of
were
his...
speeding.
I'm sorry?
Officer knows that you're going to speed, you're going to run red lights, and someone with their hands behind their back will have no way to protect themselves if I hit the brakes. A reasonable officer would know that.
Correct, but the question is whether Officer Hecker's conduct during the drive, including his knowledge that Johnson was not wearing a seatbelt, was objectively reasonable such that it violated the Fourth Amendment. And here, Officer Hecker, as I mentioned, was not swerving, was not driving erratically, and when he decelerated at the red light, it took, I believe, 5 or 6 full seconds of deceleration to stop at a red light. And the question is whether that...
But it was abrupt enough that he slammed his head or slammed his face into the shield and cut his lip open.
Well, the momentum of the deceleration did cause Johnson to fall forward, but the mere fact that he was injured does not mean that Officer Hecker's conduct violated the Constitution.
Officer Hecker responds, I'm sorry, so is that not awareness?
I think that comment goes to what Officer Hecker was thinking or what he meant by that. I think gets into subjective intent, subjective motivation, which is not a part of the objective reasonableness analysis. The focus, I think, needs to remain on his actual conduct in the case, which consisted of exceeding the speed limit and decelerating over several seconds to stop at a red light. And I'm aware of no precedent suggesting that conduct anything like that violates the Constitution.
See, that's why it surprises. I mean, this is just a reaction. You can tell me I'm wrong. It surprises me that you're kind of fighting on prong one, or you're pushing back so hard on prong one of the qualified immunity analysis, because it does seem to me that there's a real possibility a jury could find a constitutional violation here. When you take all these circumstances, you add them up, it's not Mr. O'Neill's responsibility to seatbelt himself, and yes, he was being a difficult customer that night and all that, okay, but it's not his responsibility, it's the police department's responsibility in that way. But then, it seems your position gets much stronger on prong two. Was it a clearly established violation? Just surprises me you're pushing back so hard on prong one.
Well, we argue both, Your Honors, and
No,
so I
I know-
want to make our arguments clear. And on that, I'd like to make 2 points on that. The first is that as to whether a reasonable jury could find the conduct reasonable, the important point is that in this context, it is a question for the jury to resolve disputes of fact that might determine the outcome of the reasonableness analysis. But where the facts are not in dispute, the determination of reasonableness is a legal question for the court. The second point, and I appreciate Your Honor raising it as I'd like to address.
Yeah, so all you're
second
saying
prong
with that
qualified
is just
immunity.
take all the facts in the light most favorable to Mr. Johnson, hold him static, and now go to prong two. That's all you're saying. We do that. We do this all the time.
Officer Hecker was entitled to qualified immunity because the Supreme Court has emphasized, as Your Honor noted, the need for specificity, particularly in the realm of excessive force. Johnson cites a handful of cases that he calls this broad principle of you cannot apply force to a restrained arrestee, but that is far too general or far too high a level of generality to support or to defeat qualified immunity. All of the cases that Johnson cites involve either unrelated situations, such as Salinger, where officers beat a hobbled and restrained arrestee with flashlights in the head, or other egregious situations where the officers are swerving all over the road, tossing the plaintiff back and forth around the car. One of the cases, I think the car hit a speed bump and went airborne. Needless to say, these cases do not bear any resemblance to Officer Hecker's conduct here. And so no authority clearly establishes that the manner in which Officer Hecker drove and applied the brakes violated the Constitution. Finally, summary judgment was proper on Johnson's delay of medical care claim based on causation. This court has explained that a plaintiff in such cases must present verifying medical evidence that the delay itself, independent from the other circumstances or from the impact, it's no case, and we have found none, finding a constitutional violation in similar circumstances. He argues only the broad principle that when an arrestee loses consciousness, medical intervention is warranted. But again, specificity is crucial in this context, and such general principles cannot defeat qualified immunity. With that, Your Honors, we rest on our briefing on all other matters, and we ask that this court affirm the decision of the district court.
Okay, very well. Thank you, Mr. Alperstein. Ms. Thompson, we'll give you a couple minutes. We asked you a lot of questions, and give you the rebuttal time.
I just have a few brief things to say, so I appreciate the additional time. On the excessive force claim, I just want to start with some of the questions that were asked with regard to the seatbelt and whose responsibility the seatbelt was. A defendant hacker testified in his deposition that even when a passenger in their, or an arrestee in their car refuses a seatbelt, that they are supposed to seatbelt that person, and that he usually does. So it was a conscious decision for him not to in this case. And I think that when you, the other question that was asked were, are there any facts on this claim left for the jury? I think there are facts that are left for the jury. Although Mr. Alberstein is saying, yes, we agree for purposes of the motion for summary judgment that he was speeding, and he's still, I think, disputing whether or not he slammed on the brakes or didn't slam on the brakes. I think there's also dispute about, the circumstances around what was happening in that car, if he was being asked to slow down several times or one time.
Let's move quickly, though, to the second prong.
Sure. Yeah, so on the second prong, I think that the issue is specificity, right? And so we have Seventh Circuit case law that does say on a more broad brush that when you have, and it's not just, saying, oh, anytime you hit somebody, that's excessive force. This is saying when you have a restrained individual who is no longer resisting arrest, and I think you have to look too at the factors of what's excessive force in the case law, and some of those are the seriousness of the crime, whether the person is evading or resisting arrest. None of those circumstances were present here, and under the case law, and we've cited several Seventh Circuit cases that, and the one Salinger versus Oaks is as Mr. Alberstein said. But I think the principle applies.
Stanley versus Oaks.
Salinger, Sallenger, I believe. If you need the citation, I can get it for you.
It's in your brief.
It is, yes, it's in our brief. And there's a couple of other Seventh Circuit cases that speak similarly to that proposition. But I think that
You never finished. You were saying that when there's an individual that is restrained that is not resisting.
I'm sorry, yes, that any use of force on that individual is excessive. So there doesn't need to be a use of force, and that's something that should be clear to defendant hacker. And there's also a robust consensus of persuasive authority. That is something that this court can consider, that this court, I think the Supreme Court has said that that's something that can be considered. I think this court has said that's something that can be considered. And we have cited not just one, but several cases from other circuit courts. They aren't district court cases. I think there might be a couple of district court cases, but from other circuit courts that say that this type of conduct is unconstitutional. And I think that's pretty plain. And Judge Scudder, I think you had asked a question when I was up here before about, is this something that's plainly unconstitutional? I'm not sure it quite rises to that level, but I think it is pretty clear that this is not conduct that an officer should be engaging in. And I think when you look at the Seventh Circuit cases we've cited, and you look at that robust consensus of persuasive case law, that it should have been clear to defendant hacker that this conduct was excessive force. And for those reasons, we think he's not entitled to qualified immunity. I see my time is up, so I would ask that the court reverse the district court's granting of summary judgment, and thank you for your time.
You're quite welcome. Mr. Alberstein, thanks to you and your colleague. Ms. Thompson, to you and your colleague as well. You mentioned at the outset that you took this case on pro bono as a pro bono matter. Did you take it on court appointment or just your firm doing it pro bono?
I'm not sure if the underlying case, I think the district court case was taken on pro bono, but we've taken the appeal on our own.
Okay. We very much appreciate that. Mr. Johnson should know he was well represented, and the defendants as well. So we appreciate the advocacy. We'll take the appeal under advisement. Okay, our fourth argument of the day comes in appeal number 24-2298, the United States versus Mitchell. I think it's Malega. Okay. Okay. Ms. Evans, it's nice to see you. I see Mr. Simpson's here. Okay.
Good morning, Your Honors, and may it please the Court. Irene Evans for Mitchell Malega. We're here today because there were multiple errors that occurred at Mr. Malega's sentencing. He was sentenced to 75 months on multiple counts of fraud and money laundering. There were two non-harmless guidelines errors that occurred: the application of the sophisticated means enhancement and the role in the offense enhancement as a supervisor without applying the correct standards. In addition, there were errors of applying the 3553A factors and considering information that was unreliable as criminal history. Turning first to the guidelines errors, the first that we identified was the application of the sophisticated means enhancement, which is a 2-point offense level enhancement, applying the incorrect standard under the guidelines. In 2015, the guidelines were amended such that this specific enhancement requires an inquiry into the defendant's own individual conduct rather than looking to the scheme as a whole and conspirator liability. However, the government at sentencing failed to identify any conduct of Mr. Malega's specifically that was sophisticated.
Did the district court get it wrong?
The district court did get it wrong, Your Honor.
In what way?
The district court accepted the government's arguments on sophisticated means, which articulated the incorrect standard. No alternative standard was ever articulated by.
If we accept the standard, as you have outlined for us here, that the knowledge has to be to the individual, did the judge separate out any facts that applied only to Mr. Malega?
So it's not the knowledge that has to be applied to the individual, it's the sophisticated means themselves, the actual activity.
That's what I mean, the conduct, the
Yeah.
knowledge. What did he do to engage in or to be found to be sophisticated means?
The district court did not articulate any conduct of Mr. Malega's that was sophisticated, instead resting the application of the guideline enhancement on the fact that he had knowledge of the sophisticated elements of the scheme, and the elements that the government pointed to as sophisticated was the creation of falsified documents, which they admitted at sentencing they did not know who created those documents, and they had no evidence to indicate that it was Mr. Malega who created them.
Did he not talk about, did the judge not talk about the emails?
The judge talked about the emails, I believe, in the context of the supervisory role enhancement, not the sophisticated means.
And we take the transcript as a whole, but going back to, did he articulate that Malega had a portion or played a role in creating email?
So the PSR, looking to the record as a whole, the probation
Sentencing transcript as a whole.
The sentencing transcript as a whole, the emails that were discussed there were two emails sent to a Mr. Young and a Miss Thompson. Those relaying information regarding the various frauds that occurred. Whether those were themselves sophisticated, that was not relied on by the district court, and it is not clear under the standard articulated by the guidelines that the sending of those emails is itself sophisticated means.
He's telling them in the email that how to avoid the bank discovering what's going on.
I don't know that I agree with that reading, that it's clearly about avoiding discovery. Whether those could be sophisticated means, I think that's a question of fact that needs to be resolved by the district court and was not. Turning now to the supervisory role enhancement, this is another 2-point guidelines enhancement that was applied, seemingly based on these two emails that were sent, one to Mr. Young and one to Ms. Thompson. However, there were several issues here. First of all, the district court did not resolve some factual disputes regarding authorship of the emails, which clouds the record somewhat on what exact basis we're looking at. The district court says that it's clear that Mr. Malega supervised somebody. However, his role within the company of I-80 was undisputedly supervisory, and no distinction was drawn between supervision within the company and supervision within the criminal scheme that was going on.
Why can't you look at his position? I think this is it. It's the way the government argued it, and unfortunately, the district court didn't make express findings. It more adopted, the government's position. But at least in looking at that, if you consider the defendant's position, and we know that more than 2 people worked at I-80 and the rental company. It's not just him and Mr. Jones, right? There's other people that work there. And we know that the defendant has full awareness of the fraudulent scheme going on. And he's in a position where he is communicating with the banks. He's transmitting loan draw requests to the banks. He's then receiving proceeds, and it just comes with his position that way. Why isn't that, even if you don't get caught up, set aside supervision, why isn't he playing the role of leading or managing the fraudulent activity?
So under the guidelines, supervision requires supervision of a participant, and participant is defined as someone criminally liable or criminally responsible in the scheme. No one else besides Mr. Malega and Mr. Jones were ever identified by name or otherwise as criminally responsible. Whether that's an inference that could have been...
Doesn't the guideline, though, organizer, leader, manager, or supervisor?
Correct.
Okay, what if you say he was managing it? Forget supervision, in other words.
So managing the scheme as...
Yeah, managing or leading it. So that's what I thought made your position, difficult, was the fact that he is the corporate controller, and so he's at the epicenter of the financial activity, and he's at the epicenter of that, well aware that there's a fraudulent scheme underway.
I understand your point. I think the issue here, again, turning to what the district court did say on this enhancement, is that it's clear he supervised somebody, meaning a person. So it appears the court was looking to control of another participant. However, that participant was never identified. Whether it was likely Young or Thompson, but we don't know.
Yeah, Kim Thompson?
I apologize.
Yeah, it could have been Kim Thompson.
It could have been Kim Thompson, yeah.
Mm-hmm.
We don't know who it was. There was never a finding that that person was criminally responsible, which it's a blurred record and makes it difficult to know whether the facts that were being relied on meet the test this court has adopted for this standard, which requires more than a one-off directive, but an ongoing relationship of control within the criminal scheme, not necessarily importing it from the legitimate business.
I'm sorry, go ahead.
No.
We have an acceptance of almost a $5 million bank fraud scheme.
Correct.
That continued for over a year. And so if we're going to just looking at the sentencing transcript, not parsing out individual lines, if we look at the entire sentencing transcript, is it suggestion that he was not, as the controller, managing the financial aspect of this criminal scheme?
The position is that the record doesn't indicate that specifically. That was not the basis of the application of this guideline. So whether it could have been applied on those grounds, that was not how it was applied in this case. And I'm into my rebuttal time here, so
can we affirm on any basis supported by the record?
Under some case law, this court has done so with regards to the supervisory role. Once that's United States v. Shue. Once the district court's reason for applying the guideline is found to be insufficient, the court then can look to the record as a whole, applying the 7 factors that are included in the commentary notes to see if the person matches the definition there.
Thank you.
Ms. Evans, we're going to give you your rebuttal time.
Okay.
I got one other question for you, so don't worry about the rebuttal.
Okay.
You'll get it. Okay. When there's a third argument that you acknowledged at the outset of your remarks, and that is the unwarranted sentencing disparity.
Yes, Your Honor.
Okay.
So,
one of the things that stood out here to me that I'd like for you to comment on was the district court was clearly of the view that while your client, pled guilty and accepted responsibility that way, he seemed to be kind of pulling back on that in various positions that he was taking. And one thing that struck me was he submitted a sentencing letter in advance of sentencing where he said he was ignorant and passive to the things going on around him. He probably didn't serve himself very well by submitting that position to the district court. Can you comment on that?
I can. So both Mr. Mulligan and Mr. Jones were given 2 points of reduction on their offense level for acceptance of responsibility. So to the extent that it's already included in the guidelines calculation, we do have that. Beyond that, that letter reflected Mr. Mulligan's sort of emotional reaction to what had been going on with his life and the impact that it had had on his family. However, he did plead guilty. That requires, acknowledging all the facts necessary to meet the elements of the crimes. Furthermore, Mr. Jones in his sentencing also essentially disclaimed an element by saying that not everything was done deliberately, so they're kind of in similar positions there. The acceptance of responsibility question is what the court relied on to differentiate these two defendants, but it doesn't really hold up to significant scrutiny when you consider that they both got the 2 points of acceptance of responsibility, and on neither case did the government move for the third point or object to that application.
Pulling on the thread a little bit, what was Mr. Malega's position regarding his role, looking at that letter?
His position regarding his role was that he was aware of what was going on and was acting at Mr. Jones' direction for the most part.
Okay, we'll give you that rebuttal time, and let's hear from Mr. Simpson. Good morning.
Good morning, Your Honor. May it please the court, Scott Simpson on behalf of the United States. First of all, on the guidelines enhancements here, as you observed, Judge Scudder, Mr. Malega was the epicenter of this scheme. He was the company's financial controller, basically the chief financial officer. He actually became the financial controller for I-80 equipment in July 2016, and this bank fraud scheme started the following month, in August 2016. He's the person, Mr. Malega, as the financial controller, is the person, he's shuffling the paper. He's submitting the invoices, the false invoices to the banks. It's his job to keep track of things. Obviously, financial controller, he's controlling things. He had to make sure that the alterations in the invoices were believable and hard to detect. He had to make sure, it was Mr. Malega's job to make sure that they were not actually buying the vehicles that were covered by the false invoices. They were obviously truly buying some vehicles and not buying others, and it was Mr. Malega who had to keep all of that straight. He had to make sure that the improvements that they were putting, the false improvements they were putting, that they were asking for money to cover, were believable, but again, that those fake improvements were not actually improvements that they were going to make. He was the one who had to keep track of all of this. Obviously, Malega and his co-defendant took deliberate steps to make the offenses difficult to detect, which is the core of the sophisticated means enhancement.
And counsel, for sophisticated means, but I think this would apply to manager as well. Would you agree that the district court it certainly had a lot of facts in front of it, certainly made some findings about whether, essentially saying that the scheme couldn't have occurred without either of the defendants, that they were kind of equal in that regard. But some of the findings that we'd have to make for these enhancements aren't crystal clear. We're going to be looking at facts in the record that weren't explicit findings. Would you agree with that?
Your Honor, as the court has observed already, he was relying on the PSR. The court expressly adopted the PSR, and he was relying, of course, on all the argument that the attorneys made at sentencing. On the sophisticated means, what the court said was, and again, after listening to all of this argument, after taking into account the pre-sentence report, the court said, in accepting the sophisticated means enhancement, he said, well, I think, though, this still fits the knowledge and the and part of the redirecting and hiding of assets, again, referring to the fact that it was Mr. Malega who was redirecting all of this, who was helping to hide the assets, knowing they were fraudulent. He's not relying just on the knowledge, but also on the participation, redirecting and hiding of assets. He continued, would qualify this as well for the sophisticated means.
What page are you looking at?
I'm looking at page 17 of the
Of the transcript?
of the sentencing transcript. Yes. So it's he doesn't go through it in great detail, but again, he's relying on the PSR and referring to the parties' arguments. And it was Mr. Malega himself who he was intimately involved in these sophisticated means. He was submitting the fraudulent invoices. He knew that they showed altered purchase prices, that they identified vehicles that the company did not intend to buy. And it was, again, Mr. Malega who had to keep track of all of this. He was
So
at
the
the
redirecting,
epicenter.
hiding of assets,
I'm sorry?
on 17, when he's talking about the redirecting or hiding of assets,
Yes.
knowing that they were fraudulent, that qualifies under sophisticated means.
That-
He's talking
exactly.
about Malega's conduct.
He's talking about Malega's conduct and saying that, yes, Malega qualifies for the sophisticated means. Yes. So on the role enhancement, just as it's typical for any chief financial officer or especially a financial controller of a small company not to be directly supervising a lot of employees, Mr. Malega did not directly supervise a bunch of employees, but he did have a key organizing role in this scheme. On at least one occasion, we've referred to the emails. He directed an employee at I-80 Equipment to get vehicle information, vehicle identification numbers to be included in fake invoices. And on at least one occasion, he directed an employee at JP Rentals, the other company.
Was there a finding by the district court that he did direct Jones's brother to that? I know counsel on the other side indicated maybe that behavior was not associated directly with Mr. Malega. And so I didn't know if there was a finding made at the sentencing of that.
You're talking about
The VIN numbers, directing.
You're
to
talking
get
about
the-
the one email where the defense said, well, he didn't. The defense never. The defense said, true, Mr. Malega did not generate or author that email. It came from his email address.
Okay.
So
Okay.
obviously he sent it, and I believe even on appeal, in neither of the appellant's briefs here, opening brief or reply brief, have they asserted that Mr. Malega did not send the email. I think that would be untrue.
That's
He
the
did
one
send
involving
the
that guy Yun?
It's the one from an I-80 Equipment telling him to get false invoices.
Yeah, somebody named Yun is on the other.
I believe that's yes. The other one is Kim Thompson.
Okay, there's one there. While we're on the facts, the email to Kim Thompson, that's a different email.
Correct.
Okay,
Correct.
and that involves the rental scheme
The JP Rentals.
where they were going to bump up the renovations of some house from like $100,000 to 130, or
Exactly.
101 to 130. Okay, does the PSR or the sentencing record ever show whether that appraisal was inflated and submitted?
No, Your Honor, I don't believe it does. I don't believe it. It talks. I believe the PSR talks about the email, but I don't believe it talks about the ultimate outcome of that effort with that house. So again, he played at least a coordinating and organizing role in this scheme. The guidelines, of course, allow for 3 different levels of role enhancement, 4 levels, 3 levels, and 2 levels, and Mr. Malega got the lowest, and we believe that was easily warranted under this in this scheme. Mr. Malega also, I think we need to remember, had an accounting degree. He had an MBA. He had the professional knowledge, the professional skill that were necessary to carry out this scheme. In fact, he probably could have received the special skill enhancement under 3B1.3 in lieu of the role enhancement. He was, again, the financial controller, controlling all of what was going on here with the paper flow with the banks. Turn briefly to the procedural errors with the rest of my time. First of all, the statement in the PSR about Mr. Malega's prior conduct with his prior employer. First of all, the defense never objected to that statement in the PSR below. This court has said that in that kind of situation where PSR sets it out, they make objections to other things in the PSR. The court has said, this is in the Rogers decision quoted in our brief, that is the paragon of intentional relinquishment that warrants a finding of waiver. And that's what happened here in relation to that comment in the PSR about his conduct with his prior employment. In any event, that information did have sufficient indicia of reliability, since the prior employer provided that information directly to the probation officer. And since Mr. Malega did not contest that information, the government then did not have an obligation to come forward with evidence to support it. If he had contested it, the government then would have had the opportunity to come forward with that evidence, and actually that would have put Mr. Malega in an even worse light.
I didn't read the transcript. It's definitely mentioned. That's why everybody's talking about it. But it didn't seem to play that significant of a role. What seemed to really matter at the end of the day was he was almost kind of walking back he didn't try to withdraw his plea, of course, but he was kind of walking back his acceptance of responsibility.
He was a little bit, Your Honor, but the judge did refer to the fact he said something like, this is I guess, apparently not Mr. Malega's first go-round.
Yeah, it's mentioned.
I'm paraphrasing.
That's why they're arguing about it. Yeah.
And of course, again, that's probably why Mr. Malega did not contest the information, because if the government had come in with evidence to support it, it would have made it look even worse. This was not referred to in the defense argument, but they have this argument in there about a line in the statement of reasons. First of all, we would contend that they cannot rely on that on appeal now, since it's only in the reply brief. I see that my time has expired. I could address that some more if the court has any questions on it or on any other issue.
Not hearing any questions. Mr. Simpson, you have our thanks.
Okay.
And
Thank
we give
you.
Ms. Evans the 2 minutes of rebuttal that she asked for. You're welcome.
So, responding back to a question that you asked me, Judge Scudder, about whether supervision could be found based on his role within the scheme managing assets, I would point you to commentary note 2 to that enhancement, which states that to qualify for an adjustment under this section, the defendant must have been the organizer, leader, manager, or supervisor of one or more other participants.
Okay.
So that refers to specifically supervising people. Next, we would just note that looking through the sentencing transcript, we can't find that the district court ever adopted the PSR as its factual basis on anything, or in general, as the factual basis for the guidelines enhancements that it found. And finally, just noting that the government argues today that it was Mr. Malega's job to ensure that invoices were manipulated. However, this directly contradicts their position at sentencing. If you look at page 10 of the appendix, the attorney for the government says, quote, "We don't know who altered the invoices." And I believe at another point says that they have no evidence that Mr. Malega was responsible for that. And I'm happy to answer any other questions. Otherwise, we ask that Mr. Malega's sentence be vacated and the case remanded for resentencing.
Okay, very well. We appreciate it very much. Mr. Simpson, thanks again to you and the government. And Ms. Evans, we want to extend a special thanks to you. You accepted the appointment through your law school clinic. We very much appreciate that. Mr. Malega, was very well represented. Professor Stevenson, we appreciate your clinic taking these cases on. Mr. Iverson, it's nice to see you here today as well. So with those thanks, we'll take the appeal under advisement. Our Our fifth argument of the morning comes in appeal number 24-1564, Bernard Mims versus the City of Chicago. Okay. Ms. Blogg? Flag. Nice to see. Nice to see you.
It's not as sophisticated as Blogg. May it please the court, I'm Jennifer Blagg. I'm here today representing Bernard Mims. At issue in this case is a very simple case. It's whether or not the defendant city officers violated Brady. The key centerpiece of this is recordings. Recordings that were taped or obtained pursuant to a confidential or consensual overhear. The parties don't dispute that in this case, 5 recordings were obtained from confidential overhear 13. The issue is who was responsible for suppressing 3 of the 5 tapes. Now, Judge Seeger found that Mims did not meet the burden of summary judgment in finding that the prosecutors were the responsible party. But the parties don't contest that right now Judge Seeger got it wrong. Judge Seeger said that there were pages missing from ASA Delaney's deposition for him to review, and those pages were the pages that established that the state's file had 2 tapes and 2 tapes were given to the defense. So how these recordings work, and just to briefly overview, when you have a consensual overhear, the affiant has to attest to a judge that he heard a confession. That approval, the wire is approved, then they wear the wire, tapes are recorded, those tapes are impounded. So what happened here is, how did it come to pass that the prosecutor only had 2 tapes in his file? We believe the record supports a reasonable inference that the Chicago police were responsible for suppression of the 3 tapes. The record supports a reasonable inference that the prosecutor relied on the Chicago Police Department to give him all the evidence in this case. And that's what typically happens in a criminal case. The prosecutor requests the evidence from the police turn it over. The prosecutor testified that he met with the lead detective in this case. That's when he first learned about the overhears. That's how he obtained information about the overhears. And that was long before Mr. Mims was ever charged.
Did the prosecution also have an obligation to keep copies?
The order from the COHs says that the prosecutor should keep a copy. But Mr. Delaney addressed this in his deposition, where he said the prosecutors didn't have a central repository where they kept COHs. So he did not have a place to immediately go find the COH, and he was not on the original COH. So Delaney testified, it's my typical practice, if I'm on the COH, I keep a copy of it. But he was not on this COH. And
It was the chief, right?
Pardon? Yes,
chief, yeah.
That's right. I think Tom Beastie, I'm not sure, that's from
Okay.
memory. So what we do know is Delaney said it was his practice, if he was on the COH, he would have kept a copy in the investigative file. The record shows that the investigative file in this case only contained 2 tapes. So the question becomes where, is that me? Where did those 2 tapes, where did Delaney get those 2 tapes? So when Detective Prespiora was asked, did you give Delaney copies of the COHs? He says, I don't recall. So if you take the evidence in the light most favorable to Mr. Mims, the reasonable inferences show that the prosecutor did not have access to the COHs in his file. The prosecutor met with Prespiora and learned about the COHs. The prosecutor said that he got the evidence from the COHs from Prespiora. Prespiora didn't deny that he gave the prosecutor copies of the COHs. And Delaney said he didn't keep a copy of the file in his, he wasn't involved to keep a copy of it.
Did the clerk of the court have all 5?
Yes, and so that's really important to look at that's another place that shows that Delaney supports a reasonable inference that Delaney got the copies from Prespiora, because there were 3 COHs involved, COH 3, 7, and 13, I think. COH 13 was turned over to the defense attorney pursuant to the statute because it contained information relevant to this case. COH 3 and 7 were later requested by the defense attorney. So when Delaney went to the judge, Delaney said, Judge, I was not able to obtain copies of these COHs. I need a court order to check those out. The record shows he never obtained a court order to check out COH 13. So he had to get copies from somewhere else, and he mentions it to the judge, I got copies of those other COHs. So it supports a reasonable inference, again, based on looking at the totality of the facts, that he got that from the Chicago police.
What's odd about this is I understand why Mr. Sims or Mr. Mims is very focused on Detective McNally and Officer Presapori?
Presbyora.
I understand that, but all along this information is in the court file.
No, it's not in the court file. It is impounded with the clerk of the court, which is very different. So even in this case, for us to get access to COH 13, we had to have a court order to have it checked out. So it's not in the court file.
Okay, but is it Bill Delaney?
Yes.
The ASA? Wouldn't Delaney have known about that status? That whatever the overhear recordings are, if that's the way to say it.
Yes.
That the totality of them are going to be impounded with the court.
Well, the question then becomes, was Delaney reasonable to rely on the Chicago Police Department to give him copies of the COHs? The Chicago Police Department gave him copies of everything else related to the COHs. So he said,
given that if there's something that's impounded, I know I'm not going to be as precise as you just were. Impounded with the, what'd you say, impounded with the clerk of court? Okay. If that which is not disclosed is impounded with the clerk of court, and the prosecutor is aware of that, and right?
Yes.
And it's the prosecutor that is shouldering the immediate disclosure obligation.
Yeah, well, the prosecutor shoulders the immediate disclosure obligation of the entire investigative file. Where does he get that from? The Chicago police. So,
but it's all available in an alternative source here.
Of course, but I guess if you take that logic to its extension, is it incumbent on the prosecutor to actually go to police headquarters and review all the police reports to make sure that the police gave him a complete file? Or can the prosecutor rely on the police to give them the evidence? And I submit that the prosecutor continuously relies on the police to give him a complete file. So was it reasonable for Bill Delaney to ask Presbyora for the copies of the COHs? Now, we have undisputed proof that the police kept copies.
It's an odd theory of suppression if everybody that works in CPD, works in Cook County Prosecutor's Office, is aware of how this all works with impoundment.
But
It's an odd theory of suppression that Detective McNally would have withheld this knowing that what he is withholding is in the Cook County impoundment file.
I don't think it's that odd given the fact that no one uncovered it until we uncovered it in 2021. It's routine there's nothing in the statute that says the prosecutor shall obtain the recordings from impoundment. The pattern of practice in this case, it's clear when you read the depositions, was for the Chicago Police Department to keep a copy of the recordings, to transcribe the recordings, and then in turn provide those to the prosecutor in the case. I submit it cannot be the prosecutor's burden that they have to check up on the Chicago police in every aspect of the case. Even if there's another place that the prosecutor could look, there's always another place that the prosecutor could look to check to see if the police were complying. Like I said, they could have to go. I've only gone and inspected the investigative file in one case at the Chicago Police Department, but taking this court's reasoning to its logical extension, it would require the prosecutor to go do that, to go look at the original location for every source of Brady evidence. And that's not nobody's got the time for that. They were relying on the police and working with the police to give them a complete copy of the COH.
Well, when he makes the comment, Delaney, Delaney, in May of 2005, he says, I have to go to the impound to get the remaining copies.
That's right.
Because I couldn't get it from the detectives.
Yes.
And so if the court, defense counsel, as well as the prosecution is now aware before that there are tapes that are missing.
No, they weren't aware of that. They were aware of tapes that were missing for other COHs. So this one COH 13, is directly probative on this case. You have someone admitting to confessing previously to this crime. The other COHs were ancillary. They didn't contain probative information, supposedly, about this case. So in
May 2005, he's only asking maybe for 07 or 03.
That's exactly the truth.
Okay, the prosecutor is not aware that there were 5 recordings of 13.
That's right. He was relying on the police. The police gave him 2, and 2 are in his file. So that matches. There are 2 in the prosecutor's investigative file and 2 in the defense attorney's file. So I don't think there's any question 3 tapes didn't get turned over. And I believe this court, it would be a seminal holding, I think, to say that the prosecutor could not rely on the Chicago police to give him complete recordings.
Counsel, I see you're running a little low on time. Can
I
you
am,
touch on materiality? Because
Sure.
counsel, if I'm not mistaken, knew and had reports that Sardin had confessed. And part of the reason that the verdict was overturned here was because counsel wasn't following up on those things.
Well, that's the Cook County State's Attorney's purported basis for why.
Okay.
And it also, part of their basis was he couldn't have done it because he was physically unable,
Yeah,
right?
There were additional reasons.
Right,
but,
there were
I mean,
other reasons, and I could,
how do I grapple with the fact that you're asking for tapes that you arguably had a basis already to know what they said?
so that, then you have to listen to the tapes that he did receive to understand the difference in the value of the 2 tapes. On the tapes he did receive, you hear Michael Sardin repeatedly denying he ever confessed. Man, I didn't have anything to do with that. And he's saying on BD. It's not on video. He's saying on BD, which means like on my mother, on Black Disciple is what that means. On BD, I didn't say I did that. On BD, blah, 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 blah. On the suppressed tapes, he admits to previously confessing at the basketball courts. And not only that, he knows key facts about the case. He knows what kind of weapon was used. He names 2 other people that did the crime with him. When the eyewitnesses said 3 people did the crime, he knew how the car got disposed of, and he knew how the weapon got disposed of. It's really different. Why would someone go to the trouble of suppressing these three tapes and cheating if they had no value?
Okay, we're going to give you some rebuttal time.
Okay, thank you.
Okay, you're quite welcome. Is it Merrill? Yeah, Mr. Merrill.
May it please the court. Mims contends that 2 city detectives intentionally suppressed a recording in violation of Brady, but their claim fails for numerous independent reasons. 1, there's no evidence that detectives ever possessed the recording. 2, the chain of causation is broken because the prosecution already had independent access to the recording, separate from whatever police could have theoretically provided. And 3, Mims' criminal defense counsel could have obtained the recording through reasonable diligence and accessed the impounded copy of the recording just like Mims' counsel did in this civil case. For any number one of these independent reasons, as well as the additional arguments in our brief, the district court's grant of summary judgment should be affirmed. To start with the most striking deficiency in Mims' case, while there is no evidence that the detectives ever had possession of the Richardson-Sardin recording, it is undisputed that the court had the original copy and the prosecution was required by law to possess a copy of the recording too. So not only could the detectives not have concealed a recording they never possessed, but regardless of whether they possessed the copy, the chain of causation linking the detectives to the non-disclosure is broken. Stepping back for a minute, it's important to emphasize that these confidential overhear applications are made by the state's attorney's office. And when recordings are ultimately made and impounded, it is the state's attorney's office, not the police department, that is ordered to retain copies, which under Illinois law they may not destroy. Even Delaney, the prosecutor in Mims' case, testified that it was both his personal practice and the practice within the Cook County State's Attorney's Office to maintain copies of recordings obtained from these confidential overhears in their own investigative files. And he personally knew that the original recordings were impounded at the court. Given that context, even if the police had a copy of the recording, which they did not, liability under Brady would still not attach. Brady is an obligation imposed on prosecutors. Police are only liable when they prevent the prosecutors from complying with their Brady obligations. Here, as the district court correctly explained, the detectives did not have an obligation under Brady to ensure that court-impounded materials to which the prosecution had access actually made it into the hands of defense counsel. And at a minimum, the defendants are entitled to qualified immunity on that causation point because there is no clearly established law to the contrary. So Mims' claims fails for lack of causation. Moreover, there is no evidence that the detectives in this case even possessed a copy of this particular recording. The detectives testified that they did not have copies, and the prosecutor testified that he was not aware of any copy of the recording held by the police.
Detective McNally, though, did testify that he listened to all of them.
Yeah, because he was the one involved in the underlying confidential overhear, not on the later prosecution. And so he said immediately after they recorded, he listened to them before they were retained by the state's attorney's office.
And he submitted the affidavit, right, for the application?
For the underlying confidential overhear.
So is the idea that before the originals were submitted for impoundment filing or whatever the right way to say that is, that he just listened to the originals?
Yeah, I think he was involved with the actual, let's call it, exercise of Richardson going out to get this recording, and so he listened to it either contemporaneously or immediately after, and then never listened to it again after it was.
But he had copies of a couple of them.
Well, there's no evidence that he even had copies of those two. If you actually look at what the prosecutor Delaney testified, he said he does not recall where he got these two recordings from, and McNally actually testified in his deposition that he, after that initial listening when they were first recorded, he never had them again. They were kept by the state's attorney's office. Indeed, to this day, no copy of the recording has ever been found or otherwise shown to have existed in police custody. Even the copy of the recording that we now have in evidence in the civil case today came from the court's impounded tapes, not from the police.
Can I ask another factual question? I meant to ask Ms. Blagg this, and maybe we'll give her time to, if she wants to offer a thought on it. So much of the focus seems to be on the defendant, Daniel McNally, Detective McNally, and much less focus, at least to my eye, on the other defendant, Pris Peoria?
Yes.
Okay.
I'm glad you said it out loud first.
I don't know. Okay. He's not featured very much in this. What role did he play, if any?
So my understanding, based on the record, was he wasn't involved in the underlying investigation. I believe he was part of the cold case unit.
No,
so
he was the lead investigator.
Well,
Detective for the trial.
McNally was involved in the underlying confidential overhear when they took it. Years later, when Wims was eventually prosecuted, the other detective was the one who was kind of the liaison, let's call it, for the police department.
Yeah, but that's well after these events.
Yeah,
right?
years later, and he wasn't involved in the underlying confidential overhear. In fact, in his deposition, he said he didn't even know there was any information gleaned from confidential overhears, so it just wasn't even on his radar that this existed.
Okay, but I mean, he's a remaining defendant, though, right?
Yes, he's one of the two detectives still remaining. Mims's only supposed circumstantial evidence to the contrary that the detectives even had a copy of any of these recordings is testimony explaining that the police are legally allowed to keep copies, and in some case they do in fact make their own copies. But whether police sometimes keep copies of recordings is not circumstantial evidence that specific detectives copied this particular recording. By way of analogy, the fact that it frequently rains in Chicago is not circumstantial evidence that it did in fact rain on any one day in the past. That's not how circumstantial evidence works. Nor does such testimony create a dispute of fact for purposes of summary judgment, because both things can be true. Detectives may sometimes keep recordings of confidential overhears, but these detectives did not have a copy of this recording from this confidential overhear, so both can be true and there is no dispute of fact. And the last point I would make is on reasonable diligence. A Brady claim requires that the evidence in question was not otherwise available to the defense counsel through reasonable diligence. Evidence cannot be suppressed, for example, if it could be subpoenaed by the defense counsel or through other investigative means. Here, the existence of the confidential overhear was known to defense counsel. Defense counsel knew that the original tapes were impounded with the court, and the court had ordered that defense counsel should have full access to all impounded records. Indeed, we know that defense counsel could have accessed the recording from the court because Mims' counsel in this civil case did obtain the recording from the court. To be clear, we only know about the recording because of the impounded tapes that Mims' civil counsel, through their diligence, requested, not anything ever secured from police custody. So simply put, the Richardson Sardin recording was always available to Mims during his criminal case. His counsel just simply needed to take one more step to obtain it. The city's briefing offered other additional arguments independent of why Mims' claim fails, but if your honors don't have questions on those other bases, the city's prepared to rest on its briefing.
Okay, very well, Mr. Merrill. Ms. Blagg, yeah, I'll give you a couple minutes on rebuttal.
So we have testimony from Montgomery and Delaney that the Chicago police kept copies of the COHs. Now, we could be cute with language. Maybe the detectives didn't keep a copy in their file. Maybe it was the gang unit that kept a copy in their file, which is where Montgomery worked, where they transcribed the tapes and the detectives would just have to ask for it. Presbyora had a lead role in this, and if our briefing minimizes his role, it's certainly not the intent in this. Presbyora provided a timeline to Bill Delaney that had these COHs on it. This operation was Operation Pickup. Operation Pickup had been going for years. It didn't pick up in 2003. It started in 2001 and continued throughout this time, and they were investigating various murders during that time. What happened was, in 2001, Cassandra McKee identified Mims, possibly from just looking at a single photo, and no one did anything for 2 years. That's unquestionable in this case. Why? Because the evidence against Mims was so thin, which goes to our Brady requirement. Mims didn't match the composite sketch. He didn't have a beard. He was injured. State's Attorney's Office cited that as a reason. And this Brady violation would allow Mims to highlight the woeful inadequacy of the Chicago Police Department's investigation in this case. Sarden was never interviewed. Dwayne Chester was never interviewed. The police took no investigative steps on that. They didn't document in the reports any of these various investigative steps. And I believe it supports an argument that the police sought to frame Bernard Mims because Michael Sarden was valuable to the police because he was being used as an informant on other cases.
Okay.
Oh, one more point, just briefly.
Yeah, go
Defense
ahead.
counsel, they made the point defense counsel had a duty to ask for this. Defense counsel has to be able to rely on the prosecutors to give them evidence. He asked for this evidence specifically. He was given it to him. We asked for it because we had the advantage of timelines and evidence that weren't disclosed to the defense that gave us a just belief that there was something being hidden.
Okay, Ms. Blake, thank you.
Thank you.
Mr. Merrill, thanks to you and your colleague. We'll take the appeal under advisement. Our final argument of the morning is in appeal number 25-1004, John Peterson versus Doug Collins. Good morning.
Good morning, Your Honor. If it may please the court, my name is Ronald Laniker, and I'm here representing the appellant, John Peterson. This appeal turns on process and what process is due in the context of my client's termination as a physician from the Veterans Administration in Danville, Illinois. And what we've argued here in our brief is that termination pursuant to 7462 was arbitrary and capricious, and as well was obtained without due process under the U.S. Constitution. And I will be going back and forth, but in turning to the arbitrary and capricious element of this, I do want to focus to some extent on this rebuttal. And just to provide the context here, my client...
The rebuttal evidence?
I'm sorry?
Did you say the rebuttal evidence? I just want to make sure I heard you.
That's correct. We had, my client, prior to the hearing, submitted a 154-page rebuttal.
The day before the hearing?
That's right. And this was in reference to 21 alleged charges of substandard patient care, of which the evidence file was approximately 2,200 pages. That was in the file. And my client had submitted that at that time because he wanted to make sure that he had adequately discussed and had the ability to bring up information with regards to this evidence. Now, there were issues about him having an expert, which he was not able to have. However, he asked if it could go into evidence, his rebuttal, and the AB said that they weren't able to do that. The problem with that as well was that he tried reading and tried to reference this 154-page rebuttal from while he was on the stand, as his attorney was giving him his direct, and they prevented him from adequately reviewing his rebuttal. Now, this is somebody who's facing 21 different charges of whatever it is, and this is a physician who's been treating people for over a period of several years. He certainly had an opportunity here to try to, it was difficult for him, and I think that the transcript bears this out, to adequately respond to what the DAB was asking him to respond to, because he wasn't able to actually review his rebuttal. And his rebuttal was something that, because he wasn't able to actually reference it, in fact, they wouldn't let him read from the rebuttal or read from that. They also gave him a time restriction of he had 30 seconds to review his rebuttal, and then he had to close the file and move on. Now, we're talking about patient care here, and we're talking about...
But the rebuttal evidence was not, the report, it was not admitted into evidence.
It was not admitted into evidence.
The board did give him the opportunity to refer to it when answering the question.
He referred to it briefly. However, I believe that it shows that he had trouble answering these questions with regards to this rebuttal, even though he hadn't. And his interaction with his attorney was very, very brief. There wasn't even a cross-examination by the agency, and then the DAB asked him specific questions. But this gets to another issue here as far as whether he had an opportunity to respond to the charges against him. And that's where we start to talk about he has a constitutionally protected interest in his continued employment.
He knew about the charge 1 specifications. He knew about the patients where the care was being called into question as far back as October of 2020. So by my measure, that's about 9 months before the board's hearing.
That is correct.
So he doesn't go to the hearing, without notice of what the inadequate patient care or the challenged patient care is. I don't know what the explanation is. There's something with a lawyer, what the explanation is for turning this in the day before.
I honestly, and I can't respond to that. However, I can say that he has an opportunity to be heard and has an opportunity to respond to the charges against him.
He does. In the totality of the proceeding, though, he was given that opportunity. I mean, he made a choice, and maybe he was put in a bit of a bind himself with respect to his counsel. I don't know that. With respect to the filing of this, but it wasn't like he showed up at the hearing and they were pop quizzing him about patient care that he wasn't on notice of.
Right. But again, these are things that, in the context of a physician and in the context of a patient's care, which might be a three-dimensional brick that you have to try to review, it's certainly fair for him to at least have a rebuttal and at least refer to the rebuttal as he's trying to respond to the board when they're bringing up questions or he's bringing things up to his attorney. And I think that's more of a procedural...
But they didn't comply.
They didn't comply
with the deadline of being able to turn in the rebuttal evidence. They were given over almost 90 days of opportunity to find an expert, to get that expert filed, and so they pushed, the board continued the deadline for getting those things submitted, and the day before is when this report is provided, and they said this report is not going to be admitted into evidence.
Right. And I would say that even though this report is not placed into evidence, my client still would have had the right to at least refer to the report.
And he was given that right.
He was given the right briefly, but I believe that he testified during his testimony, he wasn't able to provide clear and coherent or complete answers here based upon what the time that he was able to respond to that rebuttal and the actual parameters that were there to actually respond, to actually relate to it. And I think that, again, it's something where if you're looking at the totality of the circumstances, this is somebody who's trying to respond to a lot of different things. And it's something that you have to be referring to somebody's notes, and he certainly should have had the right to at least had an opportunity to be heard with that. So regardless of whether he should have had that at that time, he certainly should have had an opportunity to at least give his evidence and have an opportunity to be heard. And I would say that that did not happen, and that was curtailed. What I've seen here is, with Loudermill, those are things that are general. You obviously do not have to have a completely rigid approach towards it, but you have to give people at least an opportunity here to review the notes and then come up with a response. And just going into the record and giving him 30 seconds and saying he had to review it and then close whatever he had done, that's not a real opportunity when we're talking about substandard care.
He's got 9 months to prepare.
Based upon the evidence record that he has. And he did, and he tried to put that evidence, or at least orally, in the record here. And he wasn't given a proper opportunity to do that.
But he's told by the board, you can read from the evidence file, but you cannot read from the rebuttal statement.
And the rebuttal statement was the actual evidence that his response to the charges. Just looking at the evidence file itself is not necessarily proper notice here in regards.
But the notice is from the letter that outlines the specifications and the 10 charges under charge 1, specifications that they were going to pursue at the board hearing. And so he's on notice of what the allegations are, as well as what he's gonna be asked about at the hearing. So when
Right.
you say lack of notice, I'm wanting
Well,
to make sure I follow.
Maybe I'm misstepping. I'm talking more about the opportunity to be heard here, more than anything else here when I'm speaking of procedural due process. So with that, I mean, it certainly made it more difficult for him to actually respond to these charges. And, you know, regardless, we would be saying that if it was not offered into evidence, it should have been another way. But there needs to be a logical bridge here between the evidence and the conclusion here. And to that extent, the fact that a majority of these charges that had been reviewed against him, the DAB ultimately found were unsubstantiated. If he would have had an opportunity to at least review his notes and review the rebuttal, I think there certainly would have been some prejudice from that standpoint in what he would have actually been done. So the second portion of that here is when we start talking about the penalty portion of this, which we also cover in our brief. We mentioned too that the court did not actually look at the proper aggravating or mitigating circumstances here with regards to what he had actually pro-offer. And as I think as the district court noted here, this is something that was less than clear here with what DAB actually provided in with regards to what he was actually doing. So I believe I will reserve 2 minutes.
We'll give you a minute or so on rebuttal.
Okay.
Is that okay?
All right. Thank you.
Yep. Okay, let's hear from Secretary's Counsel, Ms. Sheehan.
Good afternoon, Your Honors. May it please the Court. Alicia Sheehan on behalf of Douglas A. Collins at the United States Department of Veteran Affairs. At the heart of this appeal is Dr. Peterson's request to rewrite history based on his missed opportunities. Instead, the facts and law show that the decision of the Disciplinary Appeals Board should not be disturbed. Had it not been for the board eliciting testimony from Dr. Peterson, he would have declined all opportunities afforded to defend himself throughout this process. The board correctly excluded the admission of the rebuttal statement because the statement was submitted the night before the hearing on June 1st, 2021. As Your Honors mentioned today, Dr. Peterson had ample opportunity or ample time to submit the rebuttal statement, but chose not to. He had from November 10th, 2020 until March 8th, 2021 to submit exhibits. In fact, in March of 2021, the deadline to submit motions and exhibits passed without plaintiff submitting anything, not a name of an expert, exhibit, or motion. It was not until the night before the hearing on June 1st that Dr. Peterson attempted to submit a 154-page rebuttal statement. As with any court proceeding, deadlines are vital to ensure fairness, efficiency, and finality to legal proceedings. The board clearly articulated those reasons on the record and in its written decision. Regardless, the board allowed Dr. Peterson to use and reference the rebuttal statement to answer questions. While the document was excluded, the information therein was not. To allow Dr. Peterson to read directly from an untimely and inadmissible document would unfairly prejudice the VA, with little to no ability to cross-examine or investigate the information contained in the rebuttal statement, hallmarks of the adversarial process. Moreover, as we typically see in court proceedings, witnesses are not allowed to read directly from inadmissible documents when testifying. They must testify on their own ability. Who's to say what testimony is truly Dr. Peterson's, if not in his own words? It therefore cannot be said that the board lacked a rational basis for its decision in excluding the rebuttal statement.
Can I ask you as a practical matter? In civil trials, criminal trials for that matter too, it's often common when a physician is on the stand, if you need to review a course of care in some detail, it's not reasonable to ask the physician to memorize it and to come in and sit on a witness stand. So oftentimes doctors will say, I'm happy to answer all those questions about what I prescribed on X day or what my examination showed, but I really need my file. So you can ask me whatever questions you want, and then the file is right there. Question is asked, and the doctor will refer to the file. Is that in substance what was happening here?
Yes, Your Honor, in two different ways. The board allowed Dr. Peterson to look at the evidence file, and at any point in time he could look at that, which included the medical records. And also they allowed Dr. Peterson to look at his rebuttal statement and refresh his recollection if he needed it, and then testify on his own.
Was that throughout, or was it only the 30 seconds, as counsel has alluded to this morning, at the beginning?
It was allowed throughout. Once Dr. Peterson was reminded that he could not read only from the rebuttal statement, he chose to not answer any more questions until the board continued to ask him questions.
You may be heading to this, but can you touch a little bit on the penalty determination? I think, Judge Bruce phrased it as barely enough, and it's certainly brief.
While I can appreciate that this was a shorter statement about the factors that were considered, it is our position that the board was under no obligation to make an independent assessment of the Douglas factors. There's no Seventh Circuit precedent prescribing that the board was under an obligation to make an independent assessment. And Dr. Peterson actually cites the VA handbook as authority for such proposition. However, the VA handbook states that the agency or the VA has to make an assessment of mitigating and aggravating factors, which the VA did.
So is that to say that the handbook vis-a-vis the board, and the board we're talking about is this DAB, Disciplinary Appeals Board, right? It only serves as a guide for the Disciplinary Appeals Board, but it's not binding?
That is correct. So the handbook states that the agency throughout its investigation needs to make an assessment, which it did, in a very lengthy assessment of factors, which was provided to Dr. Peterson. Further, this case that Dr. Peterson cites, which is Purifor versus the VA, is inconsistent with the law and also the Douglas case itself. The Douglas case states that only if the board finds that the agency failed to weigh the relevant factors or that the agency's judgment clearly exceeded the limits of reasonableness is it appropriate for the board then to specify how the agency's decision should be corrected to bring the penalty within the parameters of reasonableness. In addition, and this is what the 10th Circuit case in Crezo versus McDonald pointed out, is that the Douglas factors are not binding and that it is applicable only to the Merit Systems Protection Board, not to the Disciplinary Appeals Board. And that is how this court should hold as well. Even if the board was required to ensure that the VA considered the factors, the board sufficiently did so and rationally connected the facts to the board's decision to terminate Dr. Peterson's employment. And Dr. Peterson has not presented any cases that say that the board cannot rely on the agency's decision-making and the documents that they presented to the board. At a minimum, the VA's decision should not be disturbed because the analysis of the factors is reasonably discerned, which the district court found upon its review. I can touch for a moment. Dr. Peterson made other arguments that the board's decision or the VA's decision was arbitrary and capricious. However, those arguments are underdeveloped, and Dr. Peterson has not shown how there was any harm for those based on those arguments.
This is the stuff like the notice of removal wasn't signed by the right person and he didn't have a copy of all the evidence, and something about extensions of time.
That is correct.
Okay.
I can go into those if you'd like, but our position is that they're underdeveloped. That brings us to the remaining issue, the board and the VA provided Dr. Peterson with more than sufficient due process when removing him from federal service and revoking his privileges. Dr. Peterson's claim that he was denied due process is without merit and lacks legal and evidentiary support. Dr. Peterson has not articulated or identified any evidentiary issues that would have been resolved had the board ruled ruled differently. Dr. Peterson argues that he was effectively denied opportunity to defend himself, yet he was provided an opportunity at every stage from when the VA first started this investigated through the board's decision. The board provided him with the VA and the board provided him opportunities to submit written and oral statements, an opportunity to appeal, an opportunity to be represented by counsel, which he was the entire time, an opportunity to retain an expert, and ample time to review the evidence. It was not until the night before that Dr. Peterson, well past the deadline, did he attempt to avail himself of the opportunity to be heard. He had over 6 months to prepare, and when the time came, Dr. Peterson refused to provide any testimony until the board asked him and elicited testimony from him.
What do you mean by that? Can you spell that out? What do you mean just tell me what you mean factually. He refused.
So when he first attempted to review, I think on direct examination, to review his file, but when the board said that he was not allowed to do that, he stepped down, and the VA did not cross-examine him, but then the board asked to.
I know what you mean. Okay.
Yes. The record is clear that Dr. Peterson received more than legally sufficient due process. If there are no other questions, okay. Defendants respectfully submit that the court should affirm the district court and the decision of the disciplinary appeals board. Thank you.
You're quite welcome. Thanks to you, Ms. Sheehan. Mr. Lonecker, we'll give you, let me give you a minute for rebuttal if there's any point you want to make.
Just turning back to the aggravation and mitigating circumstances, the statute states that there has to reasonably discern a path. However, that is not necessarily a substitute for the process being arbitrary. They still have to consider aggravating and minimum standards. And simply reiterating the agency's findings is not sufficient. It's necessary for the agency and the DAB to articulate a connection between the facts found and the choice made with regards to the penalty. Conclusory statements or just repeating a statement from prior is not sufficient. And that's not a Douglas factor, that's basically dealing with the statute. Douglas factors are guides here, but the court still has to, or the DAB still has to look at the aggravating and mitigating circumstances, and that was found to be woefully insufficient. Thank you.
Okay. Mr. Lonecker, thanks to you. Ms. Sheehan, again, thanks to you. And the Secretary will take the appeal under advisement, and that concludes the day's arguments. Court will be in recess.